Yes.
I am maintaining in item number 3 and 7.
3 and?
3 and 7, your lord.
Yes.
So far as item number 7 is concerned, my lord, perhaps your lordship may not like to take this matter, my lord.
What's
your
7?
Lordship, 7, my lord, because your lordship appeared for private respondent in
Your Lord,
petition number.
as and when matter comes, my lord, your lordship will see at that point of time. Item 7, when matter is called out, your lordship may take up the matter.
Yeah, take up the matter at point of time.
Yes.
If that's the thing, you should have alerted earlier on. You see, you can't expect to remember what matter appeared or disappeared.
No, my lord, what my friend is pointing out now, and on last date of hearing, he did not point out.
My lord, I was not aware, my lord. After going through certain judgment, it was pointed out. Being an officer of this court, my lord, it is my duty to point out.
Let him point out, my lord.
Let the matter come up. Yes, we'll call it.
My.
Supplementary list, item number 1.
Yes.
My lord, I have some preliminary objections with regard to maintainability of this PIL, my lord.
Yes.
Now, your lordship, kindly see the PIL. Description of the PIL is page 7, paragraph 4.
Page 7. Yes. Okay.
Paragraph 4.
Yes.
Petitioner number is 1 is a former MLA, member of and so, and who work for welfare of society. Petitioner number 1 is honor of so, my lord. Now, he is a former MLA, my lord, and before the PIL is filed, my lord, everything is published in Ceylon Times, making incorrect. This is publicity interest litigation, my lord, and your lordship has framed the rules. Kindly see the rules for filing the PILs, my lord. I have prepared a compilation in Calendar, which is also relevant for this purpose, my lord. All rules and relevant provisions, my lord. It's nothing but publicity interest litigation, my lord. Your lordship will see how they are abusing the process of law. But before I take your lordship to the other aspects of
PIL rules,
your lordship kindly see the first copy of Meghalaya PIL rules, and if your lordship will see the preamble of this rule at page 1. In exercise of power conferred by Article 225 of the Constitution of India and all other powers enabling it, and in accordance with the order dated 18 January of the Supreme Court in Civil Appeal number so-and-so, State of Uttaranchal versus Sri Balwant Singh Chaufal, the High Court of Meghalaya hereby makes the following rules with respect to practice and procedure for exercise of jurisdiction under 226 of the Constitution of India pertaining to public interest litigation, my lord. And kindly see Section 1, subsection C, public interest litigation.
yes.
Public interest litigation means a writ petition under Article 226 of the Constitution of India instituted pro bono publico for enforcement of public interest,
Yes.
or general interest as distinguished from individual interest. As distinguished from individual interest in which the public or a class of a community have some interest by which their legal rights or liabilities are affected, and also include legal action initiated by court for the purpose aforesaid, or a later patent piece which may be entertained as public interest litigation under the rules. The point which I am trying to emphasize, my lord, is this, that instituted pro bono publico. Wherever, my lord, I have seen with my experience, if PIL is filed and before filing PIL, you go and release it to the press, my lord. It was there last week when PIL Cup in Ceylon time. It is not pro bono publico. It was headline that these are the materials, these are the issues which have been raised by this petitioner.
But are the issues in public interest?
They are not the issues.
Are they? Does he have a
your
personal
lordship,
interest in, like you said, a personal interest litigation? He's interested.
He is interested in publicity interest litigation, and your lordship kindly see Rule 10. Rule 10 at page 3.
Yes.
These are the rules which have been followed in violation, my lord. A writ instruction for filing public interest litigation. A writ petition intended to be public shall contain, your lordship may not be concerned with the 1. A specific averment in para 2 of the writ petition as to the source of knowledge of facts alleged in writ petition, and further inquiries, investigation made to determine the veracity of the same. Missing, my lord. I will show from pleading. A specific averment in para 3 of the writ petition specifying the class of person for whose benefit petition has filed.
General, see,
and G, my lord.
Listen, what we submit is correct is that prior to institution of this instant petition, that
Yes,
there's
sir.
been a lot of widespread media,
That is one aspect of the matter. Second, that is one.
And then whether the aspect of it is publicity, interest litigation, and that there is no there is no public interest involved at all.
Yes, sir. There are two aspects of the matter. One, Milord, is that this PIL has been instituted not in public interest. That is my first contention. Second contention.
How do you base your submissions? What are your main reasons for
I
saying that?
will place that, Milord, after why it is not in public interest, Milord. I will show that part also, Milord. The second part is that if you institute a public interest litigation, you have to take certain steps. Kindly see G, Milord. What is the requirement of G? In para 6 of the writ petition, details of representation made to the authorities concerned for remedial action and replies, if any, received thereto shall be set.
Petition, they have not
Nothing, Milord. Nothing.
Then you do one thing. You put your objections on a short
And
sort of objection affidavit. Let them answer it. We'll take it up on the next date.
Yes, Lordship. I'll place it.
If what you see is correct, that means those are.
And I will show, my Lord, and this is nothing. Everything your Lordship is seized in suo motu call, and I will show that how they have misconceived the entire petition also on merit also. I'll satisfy your Lordship on merit also.
Don't make it too long. We don't like.
I'll keep it short, my Lord.
Look at this objection. I mean.
No, because these are the judgments. What do I do with the judgments? I have to rely upon judgments.
Just make a short objection so we can take on admissibility.
I'll refer. Yes, my Lord.
Yes. Stop. As first one. As serious objections have been raised by the learned Advocate General as to maintainability of the instant PIL. Stop. Let the objections be filed in the form of short affidavit before the next date. Stop. Accordingly, this is matter for admission hearing on.
Your Lordship, as short date as possible, I am ready.
When? On 19?
19. Your Lordship may have it 19.
We won't tag it along with other matters. It'll be separate.
Yes, sir.
Yes.
Daily list item number 1.
May it please, Your Lordship.
Now, 1 second. Let us have the file. Order sheet.
Lord, SP is Jantia Hill is here before Your Lordship.
Petition. One second, we're just getting out one order. Yes, Mr. Advocate General,
Yes, sir.
you have order date 18/10/22?
18/10/22.
Yes.
Yeah.
18/10/22.
Yes, ma'am.
You have it?
18/10/2020.
18/10/22.
Yes, Your Lordship, I have it.
Yes. 18/10/20. You have it?
Yes, Your Lordship. Kindly give
Can
me
you
one
kindly
moment.
go to
18/10. Yes, I have.
page 5 of that order, last paragraph.
Yes. Chief Secretary to the State and Director General of Police will be accountable if any form of illegally mined coal is henceforth discovered in the state. The Director General of Police will instruct all Superintendent of Police in various districts to ensure that not an ounce of illegally mined coal is allowed to pass, whether in trucks or other vehicles. Superintendent of Police in all districts in the state.
Read that slowly.
Yes, I'm sorry.
Yes.
The Director General of Police will instruct all Superintendent of Police in the various districts to ensure that not an ounce of illegally mined coal is allowed to pass, whether in trucks or other vehicles. The Superintendent of Police in all districts in the state are put on notice if illegally mined coal in the state is found to have originated in or passed through their jurisdiction, they shall be held in contempt. So, the order which Your Lordship has passed on 18/10/2022, my Lord, is based on the premise, because after this order, my Lord,
Yes.
we have placed the data or
Yes.
information with regard to the
Yes.
manpower availability in each district, my Lord, including
Not only that, there is a standing sort of contempt over their heads.
Yes, Your Lordship.
They have to ensure that.
Yes, Your Lordship.
Yes.
Your Lordship has always construed the contempt jurisdiction when I do it willfully violate the order of this Honorable Court.
Now, how do you say that now, based on 18 interim report, do we still waiting for
Yes,
the
Your Lordship. Kindly
findings,
see.
Findings of Justice
Yes,
Kosaki?
Your Lordship.
But
Yes.
how do you say that, the orders of this court have not been flagrantly violated,
Yes,
continuously?
that will be my
And what's
endeavor.
happened is alarming is after, since November, after 7 November.
No, my Lord. If I because there are reports, media reports, etc.
We're not looking at media reports.
Yes.
We are only confined to the sumoto proceedings and what Justice Kosaki has found
Yes,
on
Lord.
his
Kindly
field
see
visits.
Justice Kataki's report, my Lord. I will be relying on the report only to show that there is nothing. 18th report. 18th.
See, what the saving grace you today is that we don't have the latest report with regard to the report of Deputy Commissioner.
Yes.
But even then, I've asked Suvarna Police to be here. He's been in that. You kindly stand up.
Yeah, please come here.
How many more years have you been in the district?
2 years, 10 months.
2 years, 10
and
months.
10 months, sir.
So by now you're well acquainted with the entire district.
I can say that, sir.
You're well acquainted with how your what do you call it, the movement, the volume of traffic,
Yes, sir.
the law and order situation.
Yes, sir.
Now how can you let this happen again
Uh,
under your watch? And that too, why the court's alarm, and why we've asked you to clarify why? Because if what is contained in the report is correct, then we are afraid that we'll have to take very drastic action.
my lords.
And the sword will fall on you first. You've been there for 2 years, 10 months.
Yes, sir.
And you've been through the sequence of entire events, all the orders of the court everywhere. I'm not saying suppose you really post it, we can understand. But per reports we get, it is very alarming.
My lords, if I may submit, my lords, as and when Honorable High Court of Meghalaya intervened in the coal matter by taking up sumoto PIL, my lords, what we did in district as civil...
No, we're not concerned about that. What is with regard to 18 interim report? What happened now?
Sir, I'm just one minute, sir. What happened, my lords? We picked up the inventorized coal, and any coal which was found outside the inventorized list was seized, my lord, to the tune of 75,000 metric ton of coal was seized after Honorable Court intervened in the matter, my lords. This particular coal, it is part of inventorized list as per our knowledge, my lords. Otherwise, sir, if we have seized...
So can you tell the court now, after this fact was brought to your notice, what steps you taken? What does the investigation reveal?
Yes, my lords.
Has the report been generated?
Sir, we have, my lords, we have registered the case. We have seized the coal. Section 91 notice, 2 Section 91 notice were issued. 1 to District Council to give us who is the owner of the land. Second 91 notice was issued to the Deputy Commissioner to provide us with the inventory list.
See, Mr. Police, why we are concerned is that how was there movement at all? If that is under your watch and it's the side of the highway, we can understand if somewhere in the jungle, but if the side of the highway is dumb there, a way bridge being constructed, how can it happen? It's not a connivance of certain people. There's a feeling that, because a certain person has retired from here, that, yes, that,
My lord,
everything
not
will
from,
relax.
not
And
from our end, my lord.
You take it from us that,
Your
we will
Lordship,
don't bark a lot, but
majesty of court is always maintained, my lord. Majesty of court cannot
you
be
sit down, yes. Tell him to sit down. Yes.
You can sit.
Let him sit down, please.
Now the issue is, my lord, that the Justice Kataki in 18th interim report has sought a report from Deputy Commissioner as to this coal, my lord. Now I asked for the GIS map. You show me where was it in inventorized list and where did you find the coal. If I can show the coordinates, in those the coordinates, my lord, and the coal which was noticed by Justice Kataki, my lord, there is no difference, my lord. That is
the coordinates as per the investigation report of your authorities only said that is the different coordinates.
No, what has happened, my lord, the district administration described the coal correctly in the FIR to the police, my lord. But only that's why Justice Kataki came down on Deputy Commissioner.
See, we cannot split hairs, Mr. Advocate General.
Yeah, I understand.
Because the thing is that now
we have to take a larger picture.
Why do you think? Why should we go to the entire exercise? It's because the report is furnished by your people only.
Yes, sir.
Says that the coal is inventorized of this whoever the person is in different coordinates, and the coal is discovered in different coordinates with regard to more or less.
See, the coordinates are same. If I can place that material, my lord, or we are placing it before Justice Kataki, he is going into this aspect of the matter, that whether coordinates are different or coordinates are same. If your lordship will see the...
Because we're not going to go to a fact. The only thing we are concerned with illegality.
Yes, the only thing is, my lord, that Justice Kataki went to the entire district, and entire district he surveyed it. He found the coal only at one place, my lord. Kindly give us some bona fide in the matters that we have been, because it's not that...
See, Mr. Abdul, you are standing here and making submissions well and good. We don't doubt your bona fides or your bona fides.
No, bona fide of the government. I'm
happening at the ground level.
It's bona fide of the administration of the
ground level.
No, your lordship will notice that Justice Kataki found the illegal coal in the entire place in one place only. He did the survey in the entire, and there is some confusion with regard to whether it is a part. Justice Kataki was not having the material. He said it is not part of inventorized coal. Now we have placed...
No, that's what I'm saying. Saving grace today is that we have to await the report of Justice Kataki.
That is what I am praying, my lord. That is what I am praying, my lord. Justice Kataki is looking into the matter.
Okay, we'll have it on the 19th.
Yes, your lordship may have it on 19th, and in the meantime, report may come.
Yes. Otherwise...
I understand. If it is not part of inventorized coal, your lordship is bound to take action. That we have to do.
We'll drop contempt, yes. And even...
no, dear my lord, if only one submission I have to make, my lord. Your lordship has the ample power to draw the contempt, and whether the earlier system or now. The issue is, my lord, that kindly see I have seen the data, my lord. We are trying to prevent the illegal coal mining to the best of our ability. We have got the entire more than 100 kilometer of national highway has to be monitored by this district, my lord. It is also in sensitive zone.
There's not NDPS part of the report that says that there's no women slip for a truck coming right from wherever the coal originates till where the exit point.
What is happening in the media, my lord, because now there is a lot of movement of coal because of auction which has taken place.
No, there's no women slip.
No, women's, because transit challans, and then Justice Kataki has laid down certain norms. Wherever we find that there is some problem there, in fact 75,000 has been seized here. Justice Kataki has given the report. Even Supreme Court says that you find any coal beyond this inventorized coal, you seize it and take action under Section 20 and 1. And that is also being done by us, my lord. I am not saying that we are perfect in all respect, my lord.
Question, not saying who's perfect or imperfect. No, the only thing is that to see that the rule of law should be maintained. That's
yes,
all.
That
if
is
the law says that, like we are duty bound to uphold it. You are duty bound to uphold it.
Yes, I am.
We cannot have a society which is totally oblivious to to the rule of law.
Yes.
That all the players that they feel if you can beat the system.
Yes, sir.
Maybe with the bigger picture, you can beat the system. cheat the system, beat the system.
Yes, sir. There I have nothing. If there is any attempt to hoodwink this system, your lordship will definitely
We
come
have
down.
to uphold rule of law.
Yes, yes, sir.
We all are equal stakeholders. This is a
we have
this
to
is a
do it.
national resource,
Yes, sir.
and state revenues involved.
Yes, my lord. And the moment we seize it, my lord, we do not, so any coal which is seized, my lord, we seize it, we confiscate the entire material, we confiscate. Now, what has happened, my lord, one order may help us. We are confiscating the trucks, but they are getting released on Jimmas. There also, because if the biggest...
But there is in Jimma along with the coal.
no,
inside the
no,
truck.
coal to we coal to confiscate, my lord, and auction it as per the section 21. But trucks are also, because if we are start seizing those trucks, my lord, there will be great, because what is happening is that, look, they are saying the orders, if we have to challenge those orders before your lordship time to time, where the Jimma orders are. Because in coal matters, in my humble submission, any instrument, equipment, trucks which are involved in illegal coal mining should not be released, my lord, because there is a monitoring by your lordship, there is monitoring by Supreme Court, there is a monitoring, because that is also hampering. What I got it, if we start seizing the number of trucks, because 75,000 metric ton, my lord, there is a huge, this is a huge quantity.
Okay, for unauthorized coal, what remains for auction now?
Now only my lord, only 5,50,000 metric ton, and Justice Kataki
It'll be completed by December.
No, what Justice Kataki has, because it has to be transported to the designated depots set up under and Justice Kataki has given us time, but do it by December. So that timeline has to be followed by us. That once we transport entire 5,50,000. And we are doing it, only difficulty which we are facing, which we wanted to, is that we have auctioned, Coal India has auctioned the coal on 3rd November, my lord. Now those coals have, and then transit challans have been issued to respective. Those coals are required to be lifted by
Yeah, we've heard that story before.
Yeah. And the third point, the problem which we are also facing, that the inventorized coal owners are required to transport the coal from pit head to the depot, my lord. So some of them have not come forward. We have issued notice that if you do not do by so and so date, we will seize the entire coal. So that
Anyway,
is
we'll await the report. We'll
yes.
try to get it by 19th. Yes, Inspector Police is present person today and submits that adequate steps have been taken to address the issue, and that the coal that has been noted in the area, as mentioned, the 18th interim report has since been seized. Amounts to how much? 75,000 tons.
75,000 tons.
In that
17,000 metric ton, my lord.
17,000 in that area from that Don Bosco.
No, sir. My lords, 5,000 metric ton. Overall, 75,000 metric ton.
Yes,
4,800 metric ton. Yeah, 4,800. It is a 4,800 metric ton. Give me the card list.
He submits that from the site mentioned in 18 interim report, coal amounting to 4,800 tons has been seized. Stop. Next paragraph, the Learned Advocate General also submits that the entire process with regard to the instant proceedings of the, as mentioned in the interim report, is still before Justice Kotoki, who's yet to file the next report. Stop. The court recognizes this too, that all the report, no conclusive orders can be passed at this stage. Stop. Next paragraph. Accordingly, yes, I-19. Accordingly, this is matter on 19th December to await the report of Justice B.P. Katuki retired on the report that had been called for from the Deputy Commissioner and other authorities with regard to the mentioned 18 interim report. Yes. What about it has also been submitted that next paragraph of the inventorized coal. How much remains?
5,50,000 precise.
5,50,000 ton remains to be auctioned by Coal India.
And to be transported to
be transported and auctioned by Coal India. and that as per the directives of the single member committee of Justice Kotoki, the same to be completed within December 2023. Stop. It's expected that the schedules adhered to and the remaining inventorized gold is finally disposed of by the end of the year. Stop. Next.
Yes, my lord. Champair M. Sangma.
And then the personal appearance of the Spanish police for a time being dispensed with to await further developments in the matter. Because if you come here, you come on a court, where you go from here, we find out something, we don't know where you're going. Simple as that, yes.
Item number 2.
And 2 years, 10 months you've been there. You should have your fingers on all the triggers.
My lord, this is the same matter where my friend said that there is a nexus, he will file affidavit, he's short time.
May I please, Lordship?
What's affidavit?
He said that he was making all those kind of
If I may.
allegations.
I require some more time, my Lord, because we are trying to find out substantive evidence. We'll come up with the evidence.
Without substantive evidence, they made the allegations on that day.
If my-
Now it is on YouTube, my lord.
can
Everybody
submit,
sees.
my lord.
Therefore, I request my friend, before making any allegation, he should file it, my lord.
I'll file it, my
Let
Lord.
them
Lordship
file
may take it up.
By 19th.
Lordship, may-
Mr. S. Deb prays for and sought further time to file the rejoinder affidavit allowed by order date 6/12/2023. List on 19/12.
We'll file it.
This is third item, my lord.
My lord, so far as this matter is concerned, your lordship, my lord, substantial steps have been taken, and I think, my lord,
There are certain issues
nothing-
which are there, my lord.
Yes,
This Shalendra Kumar Sharma, my lord,
yes.
is the person who is having vested interest litigation, my lord. Vested interest in this matter.
VIL.
Vested, my lord. And kindly take the item 7, my lord, for the purpose of showing vested interest, which my friend is trying to.
If I cannot take it up, now
No,
the council has said that
no, your lordship, this matter, Shalendra Kumar Sharma, my lord. Your lordship, item 3, my friend is not having any issue. He is having issue in 7, where there is a private party, and what my friend is saying that your lordships have, I don't know, because now in these circumstances, my lord, a doctrine of necessity has been evolved by Justice K. in Sahara case, I remember correctly, because we have honorable 3 judges only, my lord. Justice Bhattacharjee has recused from this.
no, but is that private respondent a necessary party in those proceedings?
It's not, my lord, state. First is state, my lord. Allegation against the state, my lord.
the allegation is against respondent number 7, your lordship. It is my duty to point it out. Thereafter, it is up to your lordship, my lord, being an officer of this court, my lord.
Last
I have
time
pointed
there
out
was
that-
no duty, my lord. Your lordship, kindly
No,
say
it
who is
was not
Shalendra
in
Kumar
my
Sharma?
notice, my lord.
Who is
It was
Shalendra Kumar
not-
Sharma? I just,
After
my lord,
going
because
through, my lord, judgments, I came to know, my lord, your lordship appeared.
But that
for
has a
respondent
bearing
number
on
7.
this. That has a bearing on the matter.
Yes, your lordship, because the matter relates to, my lord, in which your lordship appeared regarding, my lord, allotment of land for the setting up, my lord, their industry, your lordship. And it was disposed of on, my lord, 28/1/2015 in writ petition number 395 of 2013.
WPC number
395 of 2013. 2013, my
13.
13, and it was disposed of on 28/1/2015, your lordship.
How do you
And
expect
my-
the court to remember what happened 10 years
nothing,
ago?
my lord, it
To
has
your
nothing
lordship.
to do with the
Only
allegations
it is
here.
up to your lordship.
It
Since
is nothing
came
to do-
my
it is-
notice-
No, it's not up to you. Already have raised objections, so the
That
court
has
My
will
lord,
not do
I
that.
am just pointing out in future, my lord, nothing, if it is in my notice, my lord, if I am not pointing out, then
This is
question
all
will
in
come by-
malified exercise. This is all malified, my lord. I will show who is Shalendra
My
Kumar
lord,
Sharma.
saying it is very easy, your lordship. But
Your
my
lordship,
lord,
kindly
it has
see,
to be-
kindly take item 7 also, my lord, where we
Yes.
have placed material. And
They are saying, my lord,
they
I
are
am
all.
no longer director of those company, my lord.
Yes?
Yeah, I will deal with that. I will show what is the relationship, my lord. Item 7, my lord. Kindly see the affidavit. This person has filed the PIL saying that he is doing it Public interest, my lord. Kindly see his averment. Para 2.
Who is Shailendra Kumar Sharma?
Shailendra Kumar Sharma is a director in coke factories, coke companies. And he is also director or part of cement companies, is a part of group companies, and is a rivalry between the cement companies and coke companies. And he has been saying, and he has not placed a single material. Last time also my friend sought time for filing reply. On last date of hearing, I sought time and your lordship
Friday, my lord, correspondent number 7 has served me copy only on Friday, my
your
lord.
lordship, my reply was there.
replied
There was your identical allegation. Kindly see what he is saying, my lord. He page 6. The petitioner
obtaining, my
is
lord, whether
73
I
years
was or
old.
not.
Don't get excited. It's fine. Just relax.
Sorry,
My-
sorry.
My learned AG is, my lord, today he is very excited, my lord. I
Oh,
don't
you are
know, my
excited
lord.
also? Yes. Don't get excited. Just calm down.
Because wrong allegations are being
Yes.
Yeah. Kindly see item 7. Petitioner is 73 years old, senior citizen, and is working in large public interest at large against illegal destruction of environment and to unearth corruption for last 40 years. In the present case, petitioner is annexing most of the documents obtained in 2005 in support of his plea. Petitioner is being public spirited citizen. My lord, kindly see the the RTI which he has obtained. My lord, kindly see the RTI at page. Lordship will see. He has obtained at page 24, my lord. That is of 3rd September 2015.
On 15.
15, my lord. Kindly see. These are the RTIs which my friend has obtained. My friend's client, sorry, not my friend.
Yes.
Then, my lord,
What are these?
these first regarding explosive, your lordship will kindly see page 24.
No, what information these?
He sought whether the companies have obtained the explosive license or not. These companies.
What does that to do with illegal mining?
Now what he is saying that the companies are operating mining activities without obtaining the license. That is first allegation.
Explosive license.
Explosive license. That is first
no,
allegation.
mining license, your
Mining
lord.
license.
Without mining license,
Without
they
mining
are
license, they have obtained the explosive license. My lord, kindly see the second thing is also, my lord, second RTI. These all RTIs, my lord, if your lordship will see 2015 and 17. And they do not reveal anything. They do not reveal anything.
No, he's basing his allegations on what document?
The document what he is saying that the company is operating, functioning as a cement factory in Meghalaya without having valid lease permission.
Yes.
With regard to coal mining, with regard to limestone mining, my lord. So far as coal mining is concerned, my lord, I have said that this issue was examined by Justice Kataki in 4th interim report. Recommendation was made by Justice Kataki, which was approved by National Green Tribunal, my lord. And National Green Tribunal's order was set aside and matter has been remanded back to the National Green Tribunal to go into this issue, my lord. So far as this allegation is concerned of coal, that matter is pending before National Green Tribunal, Eastern Bench, Kolkata, my lord, and matter is coming up for hearing on 9 January. I will show that order, my lord. So far as limestone is concerned, my lord, limestone, my lord, because the factory came to be established in 2013. The limestone, the rules came to be framed, triple MCR, in 2016, my lord. Before that, it has been procuring and it has been paying the royalty, it has been paying the cess, it has been paying all dues. My friend has said in the PIL, without any material, that no royalty, no cess has been paid. It has obtained due permission for the purchasing limestone. Permissions have been granted and royalty and cess have been paid. My friend is saying that no royalty has been paid, no cess has been paid in the averment without there being any material. So
well,
both coal and just
I
have not finished, my friend.
Okay, yes. Continue.
My friend is excited.
Wait, Mr. Goyal. Yes.
mine.
The first is coal mill, second is limestone. Third allegation against this PIL petitioner is that environmental clearance has been obtained for higher capacity, whereas it has applied for lesser capacity to the state government.
Okay.
These are the three allegations which have been made by petitioner. My lord, kindly see the averment. A very short PIL. paragraph 4, my lord, at page 7. While later dated 13th November 2008, Director of Industries Meghalaya Shillong granted approval for setting of industries.
Yes.
Page 7, paragraph 4 of the.
Yes.
Page 7, paragraph 4. The while later 13 November 2008, Director of Industries Meghalaya Shillong granted approval for setting up industries cement plant along with captive power plant of 10 megawatt to respondent number so and so. On 9/11/2009, now your lordship kindly mark the dates 23. A public meeting was held in so and so cement plant which was going to establish having 1.5 million ton in place of 0.9 million TPA. They are producing as on today, whatever data is, they are producing only 0.9. But if I have gone for higher environment clearance, which law I have violated? I put a question to myself, my lord. It is relevant to mention that intention of company before establishment of cement plant is reflected from minutes of the meeting. Now 6, my lord, begs to state that while license, explosive license was granted to use for explosive use, it is a matter of great concern till today does not have micing. They have got LOI, my lord, and they are further respond. Prayer is to CBI investigate. Prayer number 4, my lord.
Prayer number 4.
Yes, constitute an independent inquiry into establishment and functioning of operation of cement plant operating in the state under the supervision of Honorable High Court.
How can a vague prayer?
And this is the absurd PIL which has been filed by a person who is motivated. And kindly see my reply, my lord. Kindly see my reply. They are all making mockery of the PIL on vested interest, my lord. Kindly see. My reply in this PIL, my lord. The allegations which I have received against the petitioner, my lord. 29. Earlier, I have sent it to the department to take action. Now, kindly see 29, paragraph 2, my lord.
On the past few months.
Yes, my lord. On the past few months, Sailendra Kumar Sharma has persistently requested meeting with me. However, given well-known reputation so and so. Now, kindly see, my lord, that
who's this person who wrote?
This is the person against whom we have made the arrest in that coke oven plant matter, because he said that it is a rival, my lord. He is my rival.
Better listed before some other bench. Forget Dr.
Your lordship, it is they are all because the problem is, my lord, what the problem which we are facing as on today, my lord, is that we Justice Bhattacharya has recused within the matter, and their whole effort is, my lord.
But no orders have been passed in this matter.
Yeah, no order has been passed, my lord. There is no order has been passed, my lord.
Number 7 is segregated. There's nothing. We'll be getting maybe a new chief justice soon.
My lord, my friend has succeeded to that extent.
No,
but he sought time.
No. So
Being an officer, my lord, this is my duty.
No orders have been passed here.
But only thing is that why my friend is asking for recusal, my lord. I put a question to myself.
I am not asking for recusal, my lord.
He is asking, my lord. This is the indirect way of doing it.
I am not pointing out, my lord. Then
listen, Mr. Goyal, that troubles me personally is that.
May I, with your lordship's permission.
Please listen. You're referring to, like
Lord, am I audible?
Mr.
Mishra, 1 second, yes. See, the thing is that you're referring to permissions obtained in 2008, and you said I appeared in the matter 2013, so maybe, convention and whatever propriety demands that, yes. If all events subsequent to that, I can understand. Yes, number 7. We'll pass on number 7. This is matter.
Lord, am I audible? I just want to make some submissions.
Yes, Mr. Mishra. Yes, please. Please, yes.
Well, here the objection, and which is of course making your lordship to recuse from the matter,
yes,
relates to something which has happened much before that. And in those, my lord, cases, as is stated by Mr. Goyal, the issue involved in this PIL was not involved at all. And my lord, when the advocates are elevated, they have large practice, and some of the clients will definitely be party in some future litigation.
Right,
so
Mr. Mishra, but if it makes the court uncomfortable, because that's the only thing. Because of the nature of the case.
The lawyers with large practice, they will not be able to take up any matter.
Sadly,
and they're saying.
That's correct, Mr. Mishra, what to do?
No, your lordship will take it up and decide on merit.
There's nothing on merit,
Decide on
Mr.
merit
Mishra.
because merit, as the Advocate General has pointed out, there are only 3 judges, and out of which one has already recused. If your lordship recused, this will be there till the other judges come. So
Yeah, it won't
this
be
is
long,
a
I think.
peculiar situation where your lordship has not appeared and opposed or supported the issue involved in this present PIL. Therefore, I don't see any reason that your lordship should not appear. I
You see,
remember,
one thing,
my
Mr.
lord, and
Mishra,
I think I
at the
think
outset, it has
lordship-
been pointed out by Mr. Goyal that,
That he
we are
will,
not
because he has
comfortable.
seen
And
the-
after that,
my lord, he has
backtracking
seen-
and saying that we can take it up. See, we don't want to, I don't want to get into this debate.
My lord,
Yes.
my lord, if I remember correctly, my lord, that was with regard to land transfer permission, which has nothing to do with the present.
How will a court remember, Dr. Mozika?
My lord, I can place that judgment. It is here, my lord.
I can send my judgment to my
Only
lordship.
with regard to land transfer
Same
permission.
matter, land transfer, I will recollect.
The land transfer, and this is altogether a different issue, my lord.
Totally different issue. Team sanction.
My lord, when Justice Lahiri was here in Guwahati Principal Bench, he had large practice. And while taking up the matter, he will say, yeah, I know this man. But he never accused, my lord, on this ground.
That is Justice Lahiri.
No, Lord, he also had lots in Meghalaya.
Mr. Mishra, Justice Lahiri was a sportsman. So he's very sporting.
No game is played, my lord, in the court. So he was also a judge, your lordship is also a judge. And therefore, my lord, your lordship can be considered. There will be no other person who can take up the matter, no other judge. So my submission, of course, it is left to your lordship, but my submission would be that your lordship will recuse if your lordship ever was involved with the issue which is raised in this PIL.
I'm just looking at his judgment now.
They
Whether
are wrecking up this issue because they know the consequences.
Yes.
And they also know what kind of PIL has been filed in gross violation of the PIL rules. And I'll not, without going into the merit, my lord, without even touching the merit, I will show before your lordship that this PIL is not mentionable on the face of it. This is what I would place before your lordship.
Right then. So, like, Mr. Goyal, you have no reservations any longer?
No, my lord, I have no. Just I am pointing out, my lord, let it be on 19th, my lord. By that time, I will file my affidavit.
Okay, we'll take it up for consideration. Yes.
When your
Together with
lordship
item
will
number
take
2. I'll just keep this, I'll just have a look at it.
up- My lord.
Yes. Number 7, this is the matter on 19th for rejoinder affidavit by the petitioner. Yes.
It's pleasure arguing before your lordship, my lord. It is not that, my lord, I don't want, my lord. My lord.
It is.
Hey, you know better, nobody will know
My
better
brain.
than you.
You, my
Why you
brain.
want to- why did you point out at this stage?
My lord,
You know better,
at this
you would have
after
put it out
being
the other
noticed,
day.
other day it was not in my hands. My lord, sometime my learned senior may not be aware, and sometime if it is
Number
pointed out, my
7.
learned
Number
senior
7.
will also point out, my lord.
Oh, number 7 probably. Yeah.
We
I'll record anyway. We won't record your submissions then. We'll leave it like that. That you had reservations to. Should we record your submissions?
No, my lord. I am just, if it is up to your, if your lordship feels that nothing is there, my lord, I have no problem, my lord.
Item number 4.
My lord, all these matters, my lord, are all for coke oven plant. It is in fact listed before Supreme Court today also. I have to appear in those matters by VC. 4, 5, 6. 6 is. What is 6? 6 is okay, again illegal coal. What is instruction? क्या करेंगे? Because both set of petitions are coming up before the Supreme Court today, before Justice Surikant and Justice Sundaresh.
Yes, I've just been informed that 19 interim report has been filed.
So I need a copy of your lordship.
But we
May
have not
pass
gone
the
through it
order.
also. It's been informed with the court master. Something is clear.
Lordship, pass the orders.
Yes, at the conclusion of the proceedings today, the court master has informed the court that the 19 interim report has just been received from a single member committee, Justice B.P. Katuki, a retired staff. Next paragraph. In view of the impending vacations, we are limited and the limited court days available, let a copy of the report be circulated, which we obtained by the parties from the registry in the course of the day. Yes. It is expected that on the next date, clarifications will be available as to the findings, if any, in the said report. Yes. The other matters we list on 19.
Yes, sir. All these PILs have to be weeded out, my lord. Only one suo motu should remain. Whatever issue is there, your lordship is seized with that.
In item 6, my lord, the state was directed to file an affidavit.
We'll
Six is which connected matter?
connected
Item
matter. my
6
lord.
of this today.
Connected matter. It is same connected matter, my lord.
Item number 6.
As per the last order of 20th,
Yes, Champa.
not sure.
Yes.
Yes, we'll do it before
File an
19th. my
affidavit.
lord. If it is not filed, some reply is not filed, we'll do it, my lord.
Reply
because-
from the state.
Not sure.
reply if
The
it is
the
direct.
Advocate General submits that necessary replies will be filed by the respondent before the next date. Yes. This on 19th.
Coal India has filed an affidavit. my lord.
Respondent number 6.
Mr. MZ Ahmed, Senior Counsel, so and so submits that on behalf of Coal India, the affidavit since been filed. This accordingly is.
Obliged.
Hearing item number 8.
It is what?
What is this?
Supplementary. Item number 1.
May it please, Your Lordship. My Lord, I'm Sujit Ghosh, appearing for the petitioner.
Yes. Let the file come in. What is this?
My Lord, this is a writ petition where we have challenged a show cause notice and bunch of other notifications and circulars also. And a gravamen of our concern is, my Lord, the show cause notice is predicated on a circular issued by the Central Board of Excise and Customs. That circular has been set aside by the Karnataka High Court. And if that be the case,
That exact circular is
that exact circular has been set aside by the Karnataka High Court, and therefore the show cause notice is without jurisdiction, my Lord. Briefly, the facts are as follows. 2010, I entered into a contract with NHAI to construct a 61-kilometer expressway on the Jorabat-Shillong way, my Lord. The show cause notice itself states that the work was completed in 2014.
Where the show cause notice?
Page 66, my Lord.
Or this first paper book?
Sorry, my Lord. Yes, first paper book, my Lord.
Page 66.
Page 66. Para 1
This
itself.
is 39/2023.
That's right, my Lord.
Yes.
That's right. I'll just read para 1.
Yes.
Mr. So-and-so, registered with the so-and-so and holds GST registration so-and-so, having GST declared principal so-and-so, Meghalaya. The taxpayer had incorporated SPV to execute the build, operate, transfer projects awarded by NHAI by entering into concession agreement. The taxpayer is basically engaged in development and operation of existing road from 0 to 61 kilometers on the Jorabat-Shillong Barapet section, National Highway 40 of state of Assam and Meghalaya for 4-laning design, build, finance, operate and transfer pattern on annuity basis. Now the word annuity basis is very relevant. The taxpayer is in administrative control of state GST Meghalaya, so and so under state jurisdiction, and also falls under central GST formulation, etc. of Shillong. JSEL is engaged in supply of works contract services. In response to the letter dated so and so, the authorized signatory of JSEL submitted the records mentioned in the said letter and intimated that annuity is exempt from the provisions of GST and rules and notifications number so and so, reference so and so. Further, NHAI in their reply dated so and so submitted the details of payments made by JSEL with effect from July 2017 onwards. In the said letter, NHAI has specifically mentioned that the nature of works allotted to JSEL is road construction project. I'll skip everything else, Lord. Kindly have paragraph at page 71. Page 70, para 4.2. On scrutiny of the document submitted by so-and-so NHAI,
Reading from?
page 70, para 4.2 at the bottom, my Lord.
Yes, okay, 4.2. Yes.
On scrutiny of the document submitted by so-and-so NHAI and the statement subscribed by authorized representative, it is seen that so-and-so had been awarded the Jorabat-Shillong Expressway design, build, operate, transfer BOT on annuity basis. The concession agreement dated 16/7/2010, executed by so-and-so with NHAI for execution of 61.92 kilometers on so-and-so section of the National Highway number 40 in state of Assam and Meghalaya to construct, operate and maintain the project for the concession period for 20 years. Annuity as provided in the concession agreement is payable during the concession period. Kindly see, last phase of the project was completed in 2014. But the deferred annuity payments are being received by them on a recurring basis as per the concession agreement with effect from 10/7/2014, which shall continue till 6/1/2031. As such, the agreement envisages a continuous supply of service for construction and maintenance of the road, and the consideration payable is an annuity payment. JSEL issues invoices for annuity. My Lord, I'll skip all of these things. Kindly come to para 4.3.
Yes.
As per serial number so-and-so, notification number 12 of 2017, my Lord, this is very relevant for us. As amended, exemption was provided to services by way of access to a road bridge on payment of annuity under heading 99.67. In the 43rd GST Council meeting held on so-and-so, which is 2021, it was clarified that GST is applicable on the annuity payments received as deferred payment for construction of road. As per the clarification issued by CBIC circular number 150 dated 6/2021 dated 17/6/2021, it was categorically stated that the benefit of exemption as per 23 of the notification 12 of 2017 is for annuity payment under SAC so-and-so and not under SAC so-and-so. As the agreement is for construction and maintenance of the road, JSEL is not entitled for availment of exemption under 23 of the notification 12 of 2017, dated 28/6/2017, which pertains only to services by way of access to road or bridge on payment of annuity. So the circular is the gravamen of their particular thing. Now this circular, and I'll give a brief history. 2017, July 1, GST comes into being. Under GST, my lord knows, 246A, the GST Council plays a recommendatory role. Supreme Court has held that those recommendations are binding on the central government. GST Council gave a recommendation on 6/10/2017, which my lord will find at page 847. Page 847, volume 2.
$847.
Yes, my lord. Lord has that?
1 second, it's just a bit difficult navigating all these foliage pages.
I'm so sorry, my lord.
$860. That's the third volume, I think.
That's it's in volume 2. Lords are there?
Yeah.
Well, this is the agenda of the GST Council meeting dated 6/10/2017. Agenda item 13.4, issue of annuity being given in place of toll charges to developers of public infrastructure, exemption thereon. Toll is exempt from GST. In service tax, it was in the negative list. There is a difference between toll and annuity. While toll is payment made by user of road to concessionaire for usage of roads, annuity is an amount paid by National Highway Authority of India to concessionaires for construction of roads. In other words, annuity is a consideration for the services provided by the concessionaires to NHAI. The works contract services by way of construction of road was exempt from service tax. However, service tax was leviable on the services component of such works contract. The material or goods component of the works was leviable to VAT. However, it was subject to state VAT composite rate. Construction of road is now subject to 12% GST. EPC contractors pay 12% GST on the services of road construction to the concessionaire. In view of the above, there is a free flow of ITC from EPC contractor to the concessionaire and thereafter to NHAI. As a result, GST of 12% leviable on services of road construction provided by concessionaire to NHAI would be paid partly from the ITC available with them. A view may be taken for grant of exemption to annuity payment by NHAI State Highways Construction Authority to concessionaire for construction of roads. This will amount to not taxing the value addition of the concessionaire. The argument for exempting annuity payment from GST is that the road construction services was exempt
After
from...
the show cause was served upon you, what have you done?
But we told them, in the course of the serving of the show cause notice, we told them that this was an exempted thing. We also told them that look at this GST Council minutes.
When was that done? This is dated 30th of September.
That we have kindly have page 925.
Because you come against show cause notice, so
I'll satisfy my lord on that point, my lord.
Yes, premature, yes.
Yes. 925, my lord will see a letter of ours, which is dated 19 January 2021. My lord has that?
Yeah, but is this in reply to the show cause?
No, it is what happens under GST is before the show cause notice is issued, there is a pre-consultation process that happens where you tell them.
Okay. Yes.
So
no, but referring to a letter of 2021.
Yes, that's right, my lord. 19 January 2021. There at 927, we make a reference. Kindly see agenda item 13.4, issue of annuity being given to place of toll. Whatever I just read out, we made a reference to that.
Yes.
We also said that, and the minutes of this meeting, roads as under, in fact, that was the agenda. I'll just read out the minutes. Para 61, my lord sees that, 927.
Yes.
Kindly see the second paragraph of that.
Honourable Minister.
The Honourable Minister of Haryana suggested to also cover under provisions of annuity paid by state-owned corporations. After discussion, the Council decided to treat annuity at par with toll and to exempt from tax services by way of access to a road or bridge on payment of annuity.
What was the circular you mentioned earlier?
Lord, this circular, my lord, comes to... I'll give the history to this. So after this recommendation came to be issued, the central government issued a notification which my lord will find at page 880, implementing that. Page 880, my lord, has that.
879.
Page 7.
879 our paper book.
That's right. 879 is where it starts. And in fact, in 879, the third line is very important. Let me read the preamble. In exercise of powers under Section 11(1) of the CGST Act, the central government, on being satisfied that it is necessary in public interest so to do, on the recommendation of the GST Council, hereby makes the following further amendments to notification of the government, etc. Notification so-and-so, 12 of so-and-so. Kindly turn the page. Clause D at the middle.
Yes.
After serial number 23 and the entries relating thereto, the following serial number and entry shall be inserted, namely 23 capital A, services by way of access to a road or bridge on payment of annuity. So it was exempted. Now, what happened was, 4 years thereafter, suddenly the GST Council wakes up. Now, this date is very relevant. The date of this notification is 13th October 2017. 4 years thereafter, on 28th May 2021, the GST Council wakes up and says that notification should be understood to be clarificatory and it does not apply to annuity. So they take a complete somersault, which my lord will find at page 135 of my paper book.
Okay.
In fact, my lord may have page 94 first, and then I'll take my lord to page 135. Lord has that, page 94?
Yeah, 43rd meeting.
That's right, 43rd meeting, date is relevant, 28th May 21, which is 4 years after the original notification and the GST Council recommendation was. Kindly now turn to page 135, serial number 6.
Yes.
Serial number 6, my lord, at the bottom. It was in respect of hybrid annuity model. My lord sees that? Exemption to the hybrid annuity model project SPV from GST.
Yes.
Now, there is a difference between hybrid annuity and BOT.
What's the difference?
Difference is fundamental. In hybrid, you get upfront payment and then balance over a period of time. In BOT, everything is annuity. That's the fundamental difference, my lord. I'll take my lord to that. Serial number 6, 135 on the right column. In HAM project, which is hybrid annuity model project, NHAI contributes 40% of the bid project cost during construction phase, which is the upfront payment, and balance construction cost invested by private operators is paid back to the concessionaire in 30 defined installments, along with interest as may be applicable. The payments made towards balance construction are paid as annuities. Annuity payment is exempt from GST as per entry 23A, which is now also confirmed by appellate bench wide order dated so-and-so, which is that exemption I showed my lord. However, the following decision in the said order is being contested by HAM developers, not BOT developers. So HAM developers had their problem. That only 40% of input tax credit used. I'll skip all of that because this was the problem of the HAM developers. Para 2. Industries want to have 100% input tax credit so that no cash outgo is there from the SPV as sufficient ITC is available. It is utilized against GST. The unutilized portion of ITC can be potentially utilized during O&M phase, which may be remote. Eventually, as it is not refundable, it is written off in the books of SPV as a cost. We are not concerned. 3. HAM projects are at a disadvantageous position vis-a-vis EPC and BOT projects. Clearly saying that BOT projects are different. They are only addressing the concerns of HAM projects. And basis that, now I'll take my lord to the recommendation. Kindly turn over to page 135 back, my lord. Recommendation. Lord has that?
Yes. Clarification.
Clarification may be issued by way of a circular that entry 23 capital A of notification 12 of 2017 does not exempt annuity paid for construction of roads. It only exempts services provided by way of access to a road or bridge on payment of annuity for it.
Okay.
Then they go on to explain whatever it is. I am not concerned with that.
They constricted the entire scope.
Correct. And they conflicted themselves itself completely. Kindly sum to page 137, clause 5. It would be appropriate if clarification is issued that exemption is available to only such annuities which are charged for providing access to a road or bridge at par with toll. Basis this, the impugned circular comes to be issued at page 91. Immediately, because the date is coterminous GST Council meeting was May 21 and the circular is June 21. Kindly have page 91. 92, I'm so sorry.
Yes.
May I read? Dated 17 June 21, my lord will see. Certain representations have been received questioning for a clarification regarding applicability of GST on annuities paid for construction of road, where certain portion of consideration is received upfront, while remaining payment is through deferred payment. Again, they were referring to HAM. This issue has been examined by GST Council in its 43rd meeting held on 20th May 21. GST is exempt on services falling under heading so-and-so by way of access to a road or bridge on payment of annuity, entry 23A, notification 12 of 2017, central tax, which I had read out earlier. Heading 9967 covers supporting services in transport, under which code so-and-so covers operation services of NHAI and streets, bridges and tunnel operation services. Entry 23 of the said notification exempts services by way of access to a road or bridge on payment of toll. Together, entries 23 and 23A exempt access to road or bridge, whether the consideration are in the form of toll or annuity. Services by way of construction of road fall under so-and-so. This heading inter alia covers general construction services of highways, street, roadways, airfield, runways, bridges and tunnels. Consideration for construction of road service may be paid particularly upfront and partially in deferred annual payment and may be called annuities. Said entry 23A does not apply to services falling under 9954. It specifically covers 9967. Therefore, plain reading of 23A makes it clear it does not cover construction of road.
So they made a clear distinction.
They made a clear distinction and said that this exemption will not apply.
Okay.
As soon as this circular came to be issued, the show cause notice comes, which my lord will kindly see at page 66 is where it starts, and copious reference to that will be found at page 71. Para 4.3.
The same one you showed earlier, right?
Right. My lord has that page.
But after 2 years.
After 4 years. After 4 years. Notification was of 13/10/2017. Recommendation of GST was 6/10/2017. 4 years later, 28/5/2021, GST meeting, they take a somersault. Impugned circular comes to be issued on 17th.
What do you want right now? By
Yes, my lord. I'll just show, my lord. What happened was this circular was challenged before the Karnataka High Court, which my lord will find at page 985. My lord has that?
1 second. Yes.
Yes, my lord. Page 985. DPJ Bidar Chincholi Annuity Road Project Private Limited versus Union of India. My lord has that?
Yes.
This is a decision that was rendered on 11/7/2022. Kindly turn to the page at 987, para 6. May I read, my lord?
Yes.
Yes. The case of the petitioners is that the annuity deferred payments paid for construction of road is exempt from GST as per notification number 32 so-and-so dated 13/10/2017, and the clarification issued by GST Council in this regard in its meeting held on 28 May 21 and the subsequent circular dated 17/6/2021 issuing clarification regarding the same is contrary to the exemption notification and are liable to be set aside. Para 10. Annuity is paid to the concessionaire in lieu of toll charges. GST Council in its 22nd meeting held on 2017 took note of the same, and as the entire toll charges were being exempted from GST, has decided to recommend the exemption of annuity also, which includes the construction receipt by concessionaire, which is clear from the recordings in the minutes book, which is mentioned at so-and-so. The said recording makes it clear that it recommended treating annuity at par with toll charges. Pursuant to the said meeting, the notification 2017 have been issued by respondent number 1, wherein services by way of access to road or bridge of payment of annuity has been exempted from GST, and no GST was being collected on the entire annuity being paid to the concessionaire, which included the consideration towards construction as well as for the service that they would provide towards maintenance of the said road. The reading of the recommendation of GST Council as well as notification issued makes it clear that respondent number 1 has treated the annuity being paid to the concessionaire on par with toll charges, which the concessionaires are permitted to collect from road, and both were exempt from GST. Thereafter, for reasons best known to GST Council, GST Council has clarified that annuity paid as deferred payment for construction of road highways was not exempted from GST, as the tolls or annuity in lay of tolls are. Accordingly, the impugned circular dated 21 to the petition has been issued. it is settled position of law that a circular which clarifies the notification cannot have the effect of overruling the notification. In the instant case, what has to be considered is whether the impugned circular is in violation of notification of 2017 or clarifies the said notification. As stated above, the deliberation of GST Council in its meeting dated 2017 and the notification issued pursuant thereto clearly exempts the entire annuity being paid to the petitioners towards construction and maintenance of the roads. It cannot be construed to have not exempted the annuity towards construction of road. The impugned circular has the effect of overriding the notification number 2017 and has to be held as bad in law. Nothing prevents respondent number 1 from imposing GST on the consideration paid to concessionaire like the petitioners on the payment received by them by way of annuity, but that has to be done in the manner known to law. In the incident case, respondent number 1 has issued the notification under section 11 of the CGST Act and section 6 of the integrated so-and-so, exempting the consideration received by the concessionaire from highway authorities as annuity from GST. The clarification issued is contrary to the said notification for the reasons recorded above. If the respondent number 1 is desirous of altering the same, it has to issue fresh notification amending its earlier notification. For the above reason, the impugned circular 2021 and to the petitioner is hereby set aside. Consequently, all actions pursuant to the said circular is also set aside. Our respectful submission, my lord, is as follows. If the show cause notice is predicated on the circular has been set aside by a high court, circular having a national reach, then it would apply to all the states across the country. My lord knows that. Judgment of Kusum in court, my lord. I'll just place the judgment for my lord's consideration. Yeah, Kusum in court. May I take, my lord, to the judgment, my lord? And I must also say, effective January 1, 2023, that notification entry has been deleted.
Okay.
They have done it prospectively, they had to, because they have no power to make retrospect, my lord knows, delegated legislation. And I have been paying tax thereafter. In fact, that amended notification, my lord, will find at page 913, before I take my lord to the judgment. Page 913.
Page?
913.
Yes, 931.
913.
913, okay.
Yes, may I read, my lord? 913. Notification number 15 of 2022, dated 30th December 22. Kindly have at the middle of the page, after the explanations, clause 2, serial number 23A. My lord sees that?
Yes, shall be omitted.
Serial number 23 and the entries relating thereto shall be omitted. This notification shall come into force with effect from 1st December 2023.
The root of the matter. Yes.
And I have been paying tax post this particular date. And I was showing the judgment of the Supreme Court. My lord, may kindly permit me to place that. Kusum Ingots. Lord, this is 2004-6 SCC 254. Kindly have para 22. The observations were in the context of central legislation. My respectful submission, it will apply to central circulars also. Para 22. The court must have requisite territorial jurisdiction. May I read, my lord?
Yes.
Yes. The court must have the requisite territorial jurisdiction. An order passed on a writ petition questioning the constitutionality of a parliamentary act, whether interim or final, keeping in view the provisions contained in Article 226(2), will have effect throughout the territory of India, subject, of course, to applicability of the Act. If the legislations can be struck down, my lord knows this thing. And therefore, this circular having been set aside by the Karnataka High Court, and I must also say as an officer of the court, appeal has been filed, but there is no stay on that. So far, that judgment of the learned single judge holds the field insofar as this issue is concerned.
What do you have to say?
My lord, that was one aspect, my lord, whether the judgment of the learned single judge, whether that has attained finality. and how far that is binding.
Persuasive value, you mean?
My lord, in view of the Kusum ingot, my lord, I'll not, because once a central notification has been quashed or interfered by any High
No,
Court, my lord.
but at this stage, now that order is dated, that Karnataka High Court judgment is dated, that is...
It is 11th July 22, my lord.
And what has been submitted?
And your
Appeal,
show cause is 23.
an appeal has been filed against that, my lord. That has been submitted. It is not in my knowledge, my lord. And the only case is that there is no stay on the learned single judge's order by the division bench, my lord.
At this stage, what do you propose the court to do?
My lord, what I propose, my lord, all these submissions, they have ample opportunity to say
Make
all
it
these things.
before these counsel.
My lord,
Before the, sorry. Yes.
in their reply, they can state all these facts, my lord.
No, that is the only question that the court has.
That's right, my lord. In fact, I will
The
submit.
thing is that, yes.
Yes, I'll
your
submit, my
counsel
lord.
show cause notice
I'll
at this
submit, my
stage.
lord. My lord knows, as per Kunicity principle, show cause notice can be interfered by writ court if there is without jurisdiction.
Of course.
Right? This is the case, it is without jurisdiction because the foundational attribute is the circular. Circular has been held bad in law, therefore they cannot exercise power. That is one. I wish to submit before, my
No,
lord.
but that is put before the authorities, but don't you think that...
He has ignored it.
They have ignored it.
He has ignored it.
No, they have not filed a reply, my
No,
lord.
no, no.
There is no question.
I'll
Reply.
I have said that, in fact, kindly have page 934. After my submission to them about that, etc., 934, he says,
This is dated
26/9/21.
just 21.
Yes. After the show cause notice comes to
Karnataka High
issue.
Court judgment is of 22,
That's
my lord.
fine. Kindly have. 934. 934. My lord has that?
Yes.
At 935, he makes a reference to the circular. Further, consequent upon issuance of clarification circular so and so, he records the entire circular. Then he says, from the above, it is apparent that so and so is liable to pay GST on the consideration received from NHI since July 27 onwards for forelending of the BOT. Next paragraph, in view of the above, you are requested to pay the applicable GST along with interest, etc., 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 etc. So that he has considered. Now, having said that, my lord, I must place before my lord. Kindly have page
My lord, kindly see,
1079. Sir, my lord,
Can I just?
No, I just want to point out a judgment.
The Honorable Court will again come back. My lord, that is during the course of investigation, my lord.
That's
We will
fine.
kindly say
It's the same authority.
Intelligence officer, my lord.
That's fine.
Adjudication will be done by the...
Now, what happened
Yes,
pursuant
kindly-
after
kindly
the
have-
judgment of the Karnataka High Court? What actions been taken by them? Have they
They've
apart
issued
from
the show cause.
cause? Yes, that's it.
We have taken extensions.
No, that's it.
That's it. And they will
show
do
cause,
that.
And you have
Yes.
not replied like
Right, and my lord knows.
comprehensively
Yes,
to
my
the
lord.
show cause.
Absolutely.
Have you replied to it?
My lord, we have not. We have sought an extension because we have come before my lord. I'll explain, my lord. What happens is page 107. Supreme Court holds that if an authority has issued a circular, kindly have page 1079. Kindly have page 1079. Kindly have page 1079. Kindly have page 1079.
Yes.
This is a judgment of the Division Bench of the Madras High Court, Canon India Private Limited. Para 10 may be had, 1081. May I read, my lord? May I read?
Yes.
In response to a query raised by this court as to why the petitioner should not avail the statutory remedy as provided under the Act in terms of section so-and-so, the learned senior counsel submitted that once a clarification is issued by the Commissioner of Commercial Taxes, it will bind the subordinate assessing authorities and it would be a futile exercise to go for assessment, more so when, etc., etc. So therefore, that was the thing. Kindly have para 16 onwards. This is the finding of the Division Bench after quoting a judgment of Supreme Court. From the facts narrated above, it is seen that the Commissioner of Commercial Tax has issued a series of clarifications relating to rate of tax on inkjets, toner cartridges based on requests made by the manufacturer, successive dealers, etc., etc. In the said clarification dated so-and-so, it has been stated that inkjet cartridges shall be at 12%. Now, kindly have para 18. Thus, the department appears to have taken a firm stand, wholly based on circular issued by the Commissioner of Commercial Taxes. In such circumstances, should the petitioner be relegated to avail the remedy of the Act?
See, they have not taken a stand as yet.
They have.
Since you have not filed a reply.
No, they have. In fact, they have. I'll show that.
Show the reply which after the judgment has come, after the show cause has been filed, that they've stuck.
Yes,
to the stand.
I'll show that, my lord. Kindly have.
No reason, my lord. The Karnataka High Court decision will not be appreciated by the department.
May I make a point, my lord? Kindly have page 71, para 4.3. My Lord has that?
Yes.
Para 4.3, as per serial number 23A of the notification number so-and-so, central tax as amended exemption was provided to services by way of access to abroad to a road bridge on payment of annuity under so-and-so.
Yeah, you should be.
That's right. And at the later part, as per clarification issued by CBSE. Now kindly turn to page 84. He quotes out the circular. He quotes out the circular. CBSE circular number so-and-so is reproduced below and quotes out. Then he says it's a separation at para 10. And a whopping amount of 130 crore he comes to issue on us at 10. And that is why I was making reference to the judgment of the division bench of the Karnataka High Court, of the Madras High Court. For a minute, may indulge me, page 1079. Lord has page 1082. I was reading out from page 1082. There's a discussion of the Supreme Court decision, my Lord. Page 1082. Para 18, may I read, my Lord?
1 second. We're on something else. Yes.
Yes, Lord. Para 18.
Para?
18. Page 1082.
108.
82. Yes, Lord.
1082.
Right.
Yes.
Thus, the department appears to have taken a firm stand wholly based on the circular issued by the Commissioner of Commercial Taxes. In such circumstances, should the petitioner be relegated to avail the remedy under the Act? The Honourable Supreme Court, in the case of Filter Co., considered the correctness of a decision of the High Court which dismissed the writ petition without entering into the merits, stating that there is a remedy available under the relevant enactment, namely Madhya Pradesh Jail Sales Tax Act. Interfering with the decision of the High Court, the Honourable Supreme Court held that the High Court should have examined the matter on merits, as in the case there was an order passed by the Commissioner of Sales Tax which was clearly binding on the assessing authority, and by approaching the said authority it would be an exercise in futility. Similar is the view taken by this court in the case of Pizzeria Fast Food. Several decisions to support such proposition were cited at the bar, which have been referred to supra, and it may not be necessary to refer all of those decisions. It would suffice to state to refer to the decision of the first bench of this court in WPA, etc. In our view, as far as the present case is concerned, once a clarification is given by the Commissioner of Commercial Taxes, which is the CBSE in my case, my Lord, that will bind the subordinate assessing authorities. One cannot expect a different order from the assessing officers. In these circumstances, no fruitful purpose would be served by directing the appellant to go for an assessment, and for that reason,
your entire submission that everything be futile.
It is futile.
The whole show cause futile.
Because
reply be a futile exercise.
Yes, my Lord knows that.
It comes
the
down.
Assumption of jurisdiction is based on a clarification. Clarification has been set aside. This gentleman will be bound by his clarification. He'll pass an order that he knows. And that is where the courts interfere, and I've submitted judgment. Filter Co also says that Supreme Court, it will be an exercise in futility.
We'll pass orders.
My Lord, that is one.
My Lord, the judgment cited, my Lord, how they are different, my Lord.
May I make a submission, my Lord? There are other infirmities that I must also present.
No, I mean, that's enough, yes.
My Lord, here the question is not only of surplus, my Lord. Here is a question of a judgment passed by the Karnataka High Court, my Lord. My Lord, there is no reason why department will not appreciate Karnataka High Court judgment.
No, we'll pass orders.
May I make
the futile exercise, you know.
My Lord, may I make submissions on a couple of other points which are
Mr. Ghosh, I think your submission will suffice. But yes, thank you.
Obliged.
Yes.
Obliged, my Lord.
Obliged.
Item number 2.
My lords, this is the airport land acquisition matter, my lord. The fresh inquiry reports are before my lords, and the copy, my lord, I have been appointed as amicus in this matter. If a copy may be supplied to me, lord, so that I'll be able to assist my lords.
Where were you last time?
Well, I was present, my lord. But
Courts open, yes.
yes, my lord.
Yes, Mr. Chakravarti.
We would submit, Mr. Miller, that we also may be provided with copies and
Let him see it first.
My lord.
otherwise, Miller, it's what had happened, Miller. First, an inquiry was done, and the report was submitted before your lordships, and not finding that inquiry to be up to the mark, Miller, it was sent back again for re-inquiry. And it is at that stage that three of us were allowed to participate because our names had...
With the landowners or beneficiaries?
Landowners. We had never participated, and we were more or less unaware of the acquisition. So now this inquiry which has taken place now...
You've taken part in the inquiry?
We have taken part. We have filed our claims, and evidence has been taken, and all that has been done. So this is more in the nature of a reference under the Land Acquisition Act only for a decision by the district judge. It acquires that shape, that form, because evidence has been taken and the material aspects as to the rights of the claimants and all that has been gone into exhaustively. And finally, 2 points were there on which the inquiry was to be give its findings, and the Honourable, probably the inquiry officer has given the findings.
Okay, yes. As noted by the last audit, 15/11/2023, the report by the District Sessions Judge, Sibhoi District, had been submitted. A copy of the report we made available to the learned amicus to assist the court on the next day. And we'll give copies. Let's see if he says that there's some for examination. And yes, lists after vacation.
After vacation, obliged.
Sorry, main list, item number 1.
Yes.
This is a matter regarding transfer of the postal employee.
What happened?
My lord, I talked to the department. Department is saying, my lord, we will post him somewhere nearby.
Shillong?
Not in Shillong, my lord. Around Shillong, my lord. Because he has been posted to Tura, my lord. He's agreed with that.
That on the basis of matter may be disposed of today.
Yes, it has been submitted to the bar by the learned DSGI that the petitioner that the petitioner will be
the respondent
will be posted in and around Shillong in a suitable post. Yes, the submission.
Esnath.
Your name, sorry.
Esnath, my lord.
Yes, sorry. Ms. Esnath, the council respondent, accedes to the submissions and prays that the matter on this concession may be closed.
Contempt proceedings.
Accordingly, the matter is closed. Expected that necessary action by contempt by the competent authorities be
1 month's time,
concluded in a period of 3 weeks from today.
But there are contempt pending before the CAT, my lord.
CAT, my lord, it is date fixed. If the is posted, it will matter done. That will be closed. It will be closed.
Matter stands as closed.
On that date, it will be closed.
Any mention?
From you about the Zinzatlan time to me. Shashkor, from you to many of you, I say to the economy from come. Play over high. Play you to put the money. Yes,
Mr. Lordship. I
Yes.
beg to mention item number 59, Lordship. 59, the hearing list. I pray that let it matter may come after vacation, Lordship.
Okay. Yes.
Lordship.
Yes. After vacation.
Much blessed, Lordship.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 27.
To the other side, yes.
No
2 weeks, yes.
Obliged, Lordship.
My lord, I also beg to mention item 34, my lord. This is compassionate appointment matter, and we were supposed to supply some documents, my lord. And portion of the documents you have got, the entire not yet received, my lord. After vacation, my lord. I oblige.
I beg to mention item number 32, Lordship.
Number?
32.
13.
32, Lordship.
32.
32.
Yes.
After vacation, Lordship.
Who's the your objection?
No objection.
Yes.
May it please, Lordship. Lordship, I beg to mention item 38, Lordship.
Yes.
Can you have this matter after vacation?
Objection?
No objection.
After vacation.
Deeply obliged.
Obliged, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 61, Your Lordship.
On your for the you're for whom?
Your Lordship, for
On behalf of
KHDC.
whom?
And for the petitioner, Your Lordship.
Lordship, no objection.
Yes, after vacation. Yes.
Highly obliged.
Please, Your Lordship. Lordship, I beg to mention item number 33, Your Lordship.
33.
Yes, Your Lordship. No objection.
That does matter. Yes, after vacation. First week of February. Yes. Make it quick, yes.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 42, Your Lordship.
Number?
42, Your Lordship. I pray that the matter may
42?
come up. Yes, Your Lordship, 42. After vacation, Your Lordship. And for respond number 4, 5, and 6, Your Lordship.
No objection.
Lordship, no.
Highly obliged.
May I please, Your Lordship, I beg to mention item number 60, Your Lordship. I humbly pray that
Number?
60.
60.
Yes, Your Lordship. Let this matter be taken after vacation.
After vacation, yes.
May it please Your Lordship. Your Lordship, I beg to mention item number 31. Mr. S.N. is the conducting counsel here, Your Lordship. He's indisposed.
31. Indisposed. JG Namkandri?
Yes, Your Lordship.
Okay.
Obliged, Your Lordship.
Yes.
Yes, Lordship. I beg to make a mention for item 35, Lordship.
Number?
35.
My lord, 35, my lord, this is with regard to managing committee, my lord. The tenure is expired, my lord, and they are continuing. Even after expiry of the tenure, my lord, that's why seeking.
I mean, after
adjournment time
vacation,
and
Your Lordship. After vacation.
No, we will, if they have objection.
But the matter has become infructuous, my lord, the new managing committee has to be constituted, my lord.
Let us take it up.
No, senior counsel is out of station, Your Lordship. So, senior counsel is out of station, Your Lordship.
The after tomorrow is. Due to objections, prayer of adjournment has been made by Mr. Snaitang for item number 35 and item number 36. Due to objections raised by the opposite councils, this is matter on 13th December.
Similar prayer for item 40, Lordship.
Number?
40, Lordship.
40. Yes, after vacation.
No objection.
Item number 1.
My lord, may kindly grant a pass over the learned ages before the Supreme Court arguing for the state. Before the Honorable Supreme Court arguing for the state.
I couldn't get you.
There's a matter listed before the Honorable Supreme Court. He's
After some time.
grateful.
Item number 2.
My lord, this writ petition is being filed by way of abundant caution, my lord. We are in a very confused, my lord, peculiar, confusing situation. My lord, there was a recruitment of 2021 in Nigrims, my lord, for the post of radiotherapy. Now, there were 2 posts for scheduled tribe, my lord. Petitioner number 1, petitioner number 2 took part and was successful. Now, in the meantime, they were waiting for the appointment. However, it came to the knowledge by way of RTI that there's a office memorandum of 2017, and these 2 posts which were advertised and for which the entire selection process was completed, these posts are deemed abolished. Now, under the very same OM, there's a provision for revival. Now, these 2 posts, we have not been given appointment because it is in the process of revival. Now, why we are before your lordship is because, recently in October, there's another advertisement, for 4 posts, Out of 4 posts, 2 unreserved and 2 scheduled tribe. So we have applied in this subsequent advertisement also, and exams were conducted on Saturday last. So I'm only praying for notice. The direction what I'm seeking in this writ petition ultimately is for a direction to the Department of Expenditure, Ministry of Finance, to kindly expedite the exercise of.
No, you already were selected once.
Yes, my lord.
You're happy with going for fresh selection again?
My lord,
no right. You feel that no right vested upon you by the.
My lord, age is the problem, my lord, because 30 years age limit is there, my lord. Now we cannot just keep waiting for that.
No. You already was selected once, correct?
Yes, my lord. Yes, my lord.
And then they said that the post is abolished.
Yes, my lord.
So then they have given a fresh selection.
Yes, my lord.
And for revival of the said post.
Yes.
So you're not saying that the early
no.
selection should apply. Then that's fine then. But Mr.
Just notice and an observation, my lord, that the filing of this writ petition should not be an impediment in our taking part in the process.
Yes, taking part in the process.
In this the fresh process, my lord.
Yes, but Mr. Philemon Nongbri, the council issued notice. Dr. N. Mozika.
All the response
is present. So present for acceptance on behalf of all the respondents for the notice called for. The writ petitioner's grievance is that the writ petitioner is being eligible for the post of what's that?
Radiotherapy.
Radiotherapy.
Therapy.
What is that? What's the post called?
Radiotherapy technician.
Radiotherapy technician.
Being eligible for the post of
radiotherapy
technician. One earlier selection had been found qualified for the said post, but however, due to certain developments with regard to abolition of the same, a fresh selection process has been entered into by the respondents for revival of the post.
No, my lord, what happened actually, my lord?
Yes.
Those 2 posts have been deemed abolished, my lord. In the meantime, 4 new posts have been sanctioned, my lord. Those are which have been advertised now, my lord.
Okay,
so if those are revived, there will be 6 posts, my lord.
So they'll revive 6 posts then?
If those posts are revived, my lord, the earlier 2 posts.
The process of reviving them also?
We have written to the ministry, my lord, from Nigrims.
Yes. I've been found qualified for said posts wherein there was 2 vacancies. However, as the same stood abolished at the relevant point of time. It was abolished or not abolished?
Deemed abolished.
However, as it was deemed abolished at the relevant point of time, no appointment was made pursuant to the selection process. The Learned Council submits that a fresh advertisement has been issued for selection to 4 posts, for which they have also applied. So, in this view of the matter, so the beneficial petition should not bar the petitioners from engaging in the new selection process for the freshly advertised post.
And vice versa, my lord.
Just after
vacation.
This after vacation for instructions and affidavit by the respondents.
Deeply appreciated.
Item number 3.
Please, Your Lordship.
Yes.
Lordship, I pray that Your Lordship may kindly allow this matter to come up on the 30th, Your Lordship.
Yes, Mr. Deb.
Lordship, it's a review. It's between the disputes.
Yes.
Between
Yes, my lord.
Regarding the nature of the land.
Yes, my lord. Actually, my lord, the two separate land, my lord. Last occasion, they are for instruction. Last occasion, they are seeking for instruction. They want to seek some instruction, and they have filed appeal also before the GHADC. My
What
lord.
remains?
So, my lord, if serious, then
Let it come after 1 week, my lord. Even we are trying
After-
to obtain certain instructions as to the dispute.
Counsel for the petitioner prays that some accommodation be given to absence of senior. This is the same after vacation.
My lord.
Item number 4.
Yes. Hidayatullah Qazi. Yes.
Lordship, I'm praying for some time in this matter
To do what?
for admission hearing, Your Lordship. That will come after vacation.
Yes, MS prays for some accommodation. But this is a matter of the vacations for consideration.
And you oblige. Oblige.
5.
Privity of contract, my lord.
Yes.
Their question is privity of contract, and according to me, my lord, this is a case of a substantial representations, my lord. So, my
All
lord,
the suits have been stayed.
Yes, my lord. Your lordship said,
status quo is maintained, my lord, by all the parties, my lord. Now, the only, my lord, we had approached the assistant to district judge, my lord, we have authorized the association because, my lord, who were before the ADJ, my lord,
So admission hearing today.
Admission hearing, my lord.
Yes.
You can have it after vacations,
My lord.
Yes,
My lord. Yes. In the meantime, status quo will be maintained, my lord.
On the request of party, this is a matter for admission hearing after vacations. In the meanwhile, the interim order passed earlier shall continue till next day.
Oblige.
6.
May it please, Lordship. Lordship, we've received instruction, Lordship, and we require some more time, Lordship, to file our
Do what?
affidavit.
You can't file rejoinder, forget it, then we'll
Rejoinder
have post for
affidavit,
hearing.
Lordship.
Post for hearing.
In the meantime, we'll file our rejoinder
Yes,
affidavit. Lordship.
Rejoinder as prayed has not been filed today. Has not filed till today. Stop. Accordingly, it's a matter for hearing. Petitioner permitted to file rejoinder in the meanwhile.
Deeply obliged, Lordship.
7.
May it please, Your Lordship.
Yes.
The information has come with regard to pending
Information
matters.
regarding to how many
pending
cases are there?
matters, my lord, pending matters.
So Shillong is 3.
3, yes, my lord.
West God Hills is 1. That's it.
Yes, my lord.
Nongpo is nil.
Oh, but yes. Because law department has sent me the information as in East Khasi Hill district there are 3 matters pending before me. And in Supreme Court order records altogether 4 cases, my lord. Supreme Court judgment.
Information as to the pendency of case have been received from the various districts indicating that 3 cases are pending before the in East Castle District and one West Garhills. Yes. What about computer section? They have taken steps for creating a separate tab. Where is it? This is matter after we came for the orders, because your reports wanted a report from the computer section of the High Court to be furnished before the next date, pursuant to directions of the order date 17/11/2023. Yes. You can file affidavit also if you want.
Yes, Your Lordship, because progress of the trial is the only thing which has to be monitored by Your Lordship.
So a report on progress of trial will be furnished by the who is the prosecutors? Oh, we'll call for independently. Doesn't matter.
Item number 8.
May I please, Your Lordship? Your Lordship, I filed an adjournment petition in this matter, Your Lordship. The conducting counsel, Mr. Devendra Sharma, is in bereavement, Your Lordship. His father-in-law expired.
Okay. The scene application of adjournment. Stop. Matter stands adjourned for the reasons stated therein. List after applications.
Much appreciated.
9.
Yes.
Your Lordship, I'll be filing an affidavit in the course of the day, Your Lordship.
You file course of the day?
Yes, Your Lordship.
Okay, MS Salam submits that the affidavit for respondent 3 and 4 will be filed in the course of the day. What about
2 is not required, my lord. I'm appealing.
Ms. P. Agarwal submits that no affidavit will forthcome from respondent number 2. 1 as also from respondent as also and seems also from some 2 top ne MSP Agarwal submits the no affidavit will forthcoming from respondent number 2 stop and absolute tower also submits that no affidavit forthcoming from respondent number 1. Just after applications for further orders.
10.
May I please, Your Lordship? I have to file my counter affidavit. I have filed today, Your Lordship.
Counter affidavit, you're a petitioner?
Rejoinder.
What counter?
Oh, sorry,
Origin.
rejoinder, Your Lordship.
The rejoinder has been filed by the petitioner. This is a matter for hearing after vacations.
11.
May I be Lordship?
Yes. Yes.
My Lord, this is a transfer petition, my Lord. And today is the matter fixed for the instruction, my Lord.
Wait, please, Your Lordship, we are still awaiting further instructions.
Transfer matter meaning?
My Lord, the petition is presently serving in Jammu and Kashmir, my Lord. And his representation is still pending, and my prayer is for interim protection, my Lord.
Last leg post, where Dr. Mazika?
Last leg posting, my Lord, I will be retired from service as a superannuation in the year 2026, my Lord.
You file affidavit? Yes.
My Lord, status quo may be maintained, my Lord.
Where is he serving now?
Your Lordship.
Yeah, Jammu and Kashmir, my Lord.
So you want to serve Jammu and Kashmir only?
No, my Lord, till my representation is under consideration, my Lord.
After some time, let Dr. Mazika come. Yes.
Much obliged.
Item number 12.
My Lord, deeply Lord.
May it please, Your Lordship? Lordship, as per the last order dated 24/11/2023, Lordship, we were supposed to take steps upon the respondent. Lordship, we have already taken an affidavit of service has already been filed.
What is this?
Lordship, in this matter, Lordship, the petitioner is aggrieved by the order dated 27.
No, what is this? This is regarding order of DRT.
Yes, Lordship.
And the order has been stayed
Yes, Lordship.
for recovery.
As per the last order, Lordship, 24/11.
Dr. Mosika, this is a stay of DRT order.
Lordship, the conducting counsel is Senior Advocate BP Sahu, Lordship. He's from Manipur.
How? On the pain of responding today.
Yes, Lordship.
Where's the order state?
Lordship, it is 24/11, Lordship.
Page?
Passed by Justice Dingdo.
24/11.
Yes, Lordship. Passed by
No,
Justice.
no, the order, the recovery order has been stayed. The recovery has all been executed. But if the whole proceedings are over, then how? Anyway. What are the grounds you set up for stay of this?
Lordship, some amount has been already paid, Lordship. Three properties were mortgaged.
You asked to take step which order? By order dated?
24/11, Lordship.
An affidavit has been filed today indicating the factum of service upon the respondent's number.
Sole respondent, Lordship.
Sole respondent stuff. That appears on the today. This is matter. Now we on?
Lordship, after vacation, Lordship.
After 1 week, yes.
Lordship, in the meantime, Lordship, the interim order may be stayed.
Interim order until next day. How was that order be stayed?
Obliged.
13.
My Lord, this matter last Friday, Lordship has heard. I'll just point out before the next senior makes submission. When we filed the political appeal before the executive committee, the CM also filed his show cause reply. And in his show cause reply, he did not deny that there is a practice of renewal of sanat every year. CM.
In the political appeal?
Yes.
He filed reply before the executive committee?
And he admitted that there is a practice of renewal.
Where is that?
My Lord, may I just take that?
You put in a petition?
My Lord, it is statement. We have an edge. We have an edge. On the page number 106 is my appeal, and 106. Para 107, page 107, the next page, para 1, para 4, para 5, 6, I've taken that plea, that renewal clause is there.
No, but Mr. Chare, so the only thing, the basis of your holding on to the post is that 1 year sanat, correct? Then what other right do you derive from your appointment?
My Lord, therefore there is a practice of renewal. And the Shoko's reply
is it a
of CM
convention or is it a law?
My Lord, it is the five villages.
The renewal is a convention or is it a law?
My Lord, since it is the egg is absent and every year
So the
election,
convention.
my lord, every year election is not feasible. Therefore, all the 5 villages came together and framed
But
the.
Mr. Chari, so convention is not enforceable
Madam,
in Indian courts.
Madam, then I
Only
bow
in
down.
British courts, conventions are enforceable.
Madam. Therefore, the CM, being a head of traditional authority, he do admit, my lord, his reply is page number 115, 115. Choko's reply filed by CM.
Then, do you enjoy the support of your people?
My lord, I think he's a specific government, page number 116.
Yes.
The office of the chief CM of Millennium renewed the Sanat as per the resolution passed by the Darbar Shillong. But if there is any order from the Darbar with regards to them, only the resolution of the executive committee of the Darbar Shillong is sufficient to renew the Sanat. But paragraph 4 also, 5, 6, he admitted that there is a renewal clause if there is a recommendation. In my case, recommendations are there.
Where's your Sanat?
My lord, my Sanat.
Page 75.
'75 is my Sanat. My Sanat.
Where's the term of 1 year?
My lord, the term is mentioned, the first one, medium steamship for a period of 1 year.
Where
It
is
is
that?
mentioned under the Act.
Where is that?
My lord, as empowered by Section 16(2) of the 2007.
Oh, yes.
And my lord. So it is mentioned there. That is true. And now, page number 87, they filed a complaint against me. And
That's why it's not renewed.
my lord, here no one, my lord, at the time of filing a complaint, my term was not yet over. My lord. Not yet over.
But
and
you were not removed right when the complaint was filed.
I was not removed.
You continued to your whole term.
My lord, I continued. And thereafter, my lord, what happened? The CM issued notice to me also. We appear, even the complainant also appear, and the Mantri has heard both of us.
What's the election notice?
My lord, the notice is page number 91, my lord. Type copy is, my lord, page number 90. Page number 90 is a type copy of the notice.
91 is not election notice.
But it is not election notice. After complaint received by CM issued Choko's
What election notice?
Notice to me.
What's the notice for election? Where is it?
Oh, notice for election, my lord. That is page number, my lord, 134. The last, 134. Is a type copy, my lord. We have an X.
Okay. Yes, Mr. Gandha.
Your Lordship, in fact, from paragraph 4 of the writ petition, it is clear that there was a complaint by 137 residents of the area, and consequence to the complaint, the chief did not he caused an inquiry. But irrespective of the inquiry, Your Lordship may have a look at page 102, is Annexure 8. This is the election, and this is the thing, main. Your Lordship is with page 102. The chief and his Darbar of Millennium Simship hereby make a public announcement in Umsning Patarim village, right Mabu, Millennium Simship, that Shri so-and-so has been removed from the post of headman of so-and-so after expiry of his sanat.
So you serve for more than 1 year, that means?
Yes.
By this time, 1 year over.
Yes. And it is not on the basis of the complaint. We did not take action on the basis of the complaint. Be that
what happens to the complaint that's before the committee now? Filed by those people. What happens to the complaint?
Consequent to this Annexure 8, the writ petitioner filed an appeal before the executive committee, and the executive committee
What about a complaint filed by those people? Has it been taken up by the, who's up in email him?
Taken up the complaint.
And what has happened to the complaint?
Dispose of the complaint agreed by the order that.
No, how you dispose it of? You dismiss the complaint?
We have summoned the parties to appear before the office after hearing all the parties concerned.
No, what? You dismiss the complaint or you upheld the complaint? Or you found the petitioner guilty of the complaint?
Guilty on it.
Where's the order?
I am very sorry, I don't have the brief with me, unfortunately.
Don't make those excuses.
Tragic incident happened in the house of the conducting counsel. As such, the brief.
What happened?
Some robbery took place this morning. Some mishap happened.
Who's conducting counsel? Robbery took place in his house in Shillong?
This morning.
No.
The previous victim.
Then we'll adjourn it.
Lordship, the village is without a headman.
Yes, of course, we'll adjourn it till...
Administrator is there.
And
They
my
have already
colleague-
appointed administrator.
My colleague is relying
Day
on...
after tomorrow?
Yes, Lordship.
Interim may continue till tomorrow, day after tomorrow.
Day after tomorrow. As some inconvenience, some incident occurred in the house, conducting counsel is after today. What's for correspondent number? Number 3, try to produce order. Number 3 and 4, list this matter on 13th. The council is going to bring relevant material on board on the next date, yes. Good.
I look.
14.
Much appreciated.
Yes, Mr.
Maybe His Lordship. Lordship, I pray that I may be allowed to file a counter affidavit in this matter, Lordship.
Why?
Lordship, I have just received instructions this morning, Lordship, and...
What are the instructions?
Lordship, there are several complaints which are lodged with the BDO.
So why not giving official approval? If the report says the elections were held in a fair and transparent manner as recorded in the last order.
Lordship, that is on this basis, Lordship, because he's still getting complaints.
What are we getting complaints?
From the other parties, Lordship. And
other parties who lost elections. That means on the basis of a complaint,
Lordship,
some other person, then let him file election petition.
Lordship.
We wanted you to come with specific instructions. That is why.
Lordship,
within 1 week.
Lordship,
sure instructions received. Let us see.
Lordship, I've marked also the relevant complaints and along with the letter he sent to the DC.
This is by the BDO?
Lordship.
Who'll run the affairs then?
Lordship, as
how all development work be carried out?
Lordship, the state government in the interim will be.
There is no one, Lordship. There is no one.
Instructions are very. Look at the nature of complaints. What kind of inquiry will he go into? That she's illiterate, her behavior is not acceptable, could not complete work, so husband could not complete work.
She is contesting for the first time, Lordship, and how can?
Yes, take down. The writ petition concerns the non-approval of the VEC of, what village is this?
Tungrusar, Lordship.
What village?
Tungrusar, Tungrusar.
Tungrusar village. Stop it has been submitted by Ms. S.A. Sheikh that though the elections were conducted as far back as on 28th or 29th?
Election was held 29, Lordship, 29th August.
28th or 29th
29.
August 2023, and the writ petitioner emerged victorious.
Yes,
Had been elected secretary. No approval had been granted to the said newly constituted VEC. By order dated, next paragraph, by order 1/12/2023, the Learned GA Mr. A. Kharwanlang was directed to obtain instructions, which he has produced today. A perusal of the instructions shows that certain complaints are still being looked into by the concerned authorities, that is the BDO, on the formation of the VAC. Though this excuse is not acceptable, in as much as if a person is elected by the majority, the logical by the majority, he or she is to naturally assume office. However, nature of complaints on perusal of the instructions, this court await the passing of final orders consequent upon the inquiries that are ongoing. Ongoing, correct?
Inquiry is held, Lordship.
Ongoing. This is dated.
Lordship, I just received this morning, Lordship.
Inquiry was done.
Which is ongoing on fresh complaints.
Also, there are two complaints.
See, I think what is video? I just may tell you. What he says is that whatever it is, election may have won, but then if any particular person or group is allowed to run, there will be breaking of heads.
That is the report given by the video.
Not breaking of heads, but there will be chaos. That's the thing. I don't think this will be relevant material to put on affidavit also.
The first complaint, my Lordship has already perused the complaint, what type of complaint they have given, and that it was that video has conducted the inquiry through the Ombudsman.
Lordship,
the inquiry has given the finding that nothing has been found.
This is a different petition. Where's the 230 is what? 380.
380, Lordship.
380, Lordship.
Why the annex the same old paragraphs coming again?
230, that was the earlier writ petition, Lordship. Because election was not held, that is why I approached this honorable court, and during the pendency, then they have decided to conduct the election. Thereafter, that writ petition I have withdrawn, Lordship.
An inquiry last reported from when was the inquiry reported?
Inquiry 19 September 2023, Lordship. That too also on the strength of the order given by the Deputy Commissioner, Lordship.
See, we don't want to pass orders, without knowing the ground situation, whereby, it might result really breaking of heads. Sometimes courts pass some orders to, implement some action, but then
no, let them to come up.
So this, yes, Thomna?
That is not the issue, Lordship.
On the fresh complaints filed by the persons mentioned in the instructions, the report should be supplied to this court by
Lordship, 2 weeks time may be given, Lordship.
2 weeks, the court will be closed.
Lordship, I can come during the vacation.
You'll come where to do vacation? You'll come to my house?
For vacation bench, Lordship, if required, Lordship.
Or you go for vacation, you said?
If there's a vacation bench, Lordship, I can produce it there.
And we can't fix matters to vacation, must be urgent matters. Yes, Sir Thomna? Should be supplied to this court on the next date fixed as to what action has been taken by the BDO. and whether the complaint has any basis, in as much as in the early inquiry dated.
Inquiry.
Inquiry dated.
It is 19 September 2023, Lordship.
Dated 19 September 2023, the election was found to have been held in a fair and transparent manner. Stop. This is matter on reopening. Yes, on reopening, yes.
Highly obliged.
Master.
15.
Yes, has food grain been distributed?
Yes,
In this case,
the food
Your
grain
Lordship,
is being distributed. August
now
and
started.
September has already been distributed, and October, November is ongoing, Your Lordship.
Yes, August is given, Your Lordship.
August, September has been given, Your Lordship.
So what do you want us to do now?
So, Your Lordship, this during pandemic they are not given this still.
Forget pandemic. What do you want now, today?
Now, Your Lordship, this year when they have started to give it up to August.
Yes, MST Yangi submits instructions that the distribution of food grains has commenced, and for the period of August, the same has been completed, and
Till September
for
it's been
till September
completed.
it's been completed, and for
October, November is
October,
ongoing.
November is ongoing. Stop.
Then, Your Lordship, I also make a small prayer that the respondents number 5, 6, and 7 who have been given by name, Your Lordship, their names may be struck off and they may be kept there as in their official capacity.
You file affidavit, yes. She is allowed to file the same affidavit. Stop. Prayer has been made for striking off the names of the respondent numbers.
5, 6, and 7, Your Lordship.
5, 6, and 7 who have been personally who have been with party in by name. Stop. Matters will consider the next date. Yes. File affidavit first.
16.
And we see that no, that's been done, then we'll talk them.
16.
Oblige, Your
The inquiry report is still under consideration, my lord. I have not received
What
the copy.
inquiry report? This is a rank composition matter?
Rank composition matter.
By whom? Who is examining?
My lord, ministry appointed one of the senior officers of BSF, my lord, to conduct the inquiry. He has conducted the inquiry and submitted a report to Ministry of Home Affairs.
Dr. N. Mozika today also submits that the report is even submitted by the BSF. It's still a consideration Ministry of Home Affairs. Stop,
By a BSF officer, my lord. He was interested by name, my lord, to conduct the inquiry.
What's his name?
I think DIG.
DIG can't be his name. What is his name?
By
no?
ranking BSF officer.
Actually, Your Honor.
Yes.
A joint survey was conducted and the report was to be made by the MHA here.
The report of the inquiry is submitted by Dr. Mozika. The report of inquiry is still under consideration in Ministry of Home Affairs. Stop. He prays that the matter be adjourned today to be able to obtain specific instructions on next date.
Your Lordship, item number 16 to 26 and 28 to 30 are connected.
Okay, take down. 16 to 26,
28, 29, 30, Your Lordship.
Okay, yes.
25, 25, 26, 29.
Obliged.
Second call.
Highly obliged.
Question number 1.
My Lord, this matter relates to the appointment of the primary teacher. Lordship is aware, RTE came into being in 2009, and the central government empowered the NCTE to formulate the requirement for qualifications. Now, 23rd August 2010, NCTE formulated the policy and laid down.
We are aware of that. I think one judgment passed. Is the same party.
One person is the same party.
Appeal against the order.
My lord, he is satisfied with that first. He applied in the West.
He's satisfied with that order dismissing his writ petition?
My lord, my lord.
No, appeal is filed, my lord.
No,
appeal,
no.
LPA, I have seen. I have received a copy of appeal against the
He is
order
not-
of your lordship.
he is
But
not
the
the party.
issue here, my lord, is
Defend subdivision, my lord. He applied for other Southwest Karo Hills. There he filed a writ petition. Lordship dismissed that one. And he
Tadantiri
applied for
only.
the West Karo Hills. And while West Karo Hills, another order was issued. Now, along with him, another 4 more petitioners are here who specifically applied for the Tadantiri subdivision only. May I just brief the
only
advertisement?
one preliminary objection, my lord. One preliminary objection. The petitioner says that he is not having the qualification and he is not entitled to be appointed. He is not entitled to be appointed, and then thereafter he is not a person aggrieved, my lord. If he is not entitled to be appointed, he can't challenge the process of appointment, my lord. That's the law. That's it.
Is that what your...
Averment is there, my lord, paragraph 3.
Are you eligible for... if I remember correctly, the court has held that B.Ed is not a suitable qualification for primary school.
Yes.
You should have DLET, diploma, correct? Yes.
Right.
And I saw that, when was the other judgment given, Mr. Advocate General?
Yes, your lordship, this
So
judgment...
It was given on?
It was given on... your lordship's judgment is here. In
On
the...
page
it was given
93.
on... it was given on 21/11/2020.
And Bihar High Court decided just yesterday.
Yes,
or day
yesterday
before,
only.
and
I
it's
saw
come on
that.
live
also.
law that
yes,
is,
your
is
lordship.
found that.
I went through same view what has been taken by your lordship. Same view.
Page
Before
number
that we
93.
decided.
Page 93 is my lord's judgment.
But that
Page
issue
93.
will not come, my lord. The issue is what they are saying, my lord.
A totally different issue.
And completely. Kindly see paragraph 12 of their own petition.
I will satisfy, my lord.
Paragraph 12, my lord.
No, what do you want now, Mr. Chareso?
My lord, what happened? The advertised.
Is it correct? Okay, the first question. Is it correct that as you are situated today, you're not eligible to apply for the post? If I remember your B.Ed.
I was not having a B.Ed. I was having a graduate B.Ed. But I didn't have a DLED. DLED. But now advertisement says that those who have a DLED or the B.Ed graduate can apply. Therefore, I applied. Now, during the process of that...
No, that's over.
That is over.
What qualification do you possess in your hand right now?
No, I have a B.Ed.
You're a B.Ed now.
B.Ed.
Now that means you're not qualified to apply for the post of primary teacher, correct?
Yes.
Now then, what is your grievance now?
Now, my grievance is, in view of the fact, in view of the Supreme Court judgment and my Lord judgment, I'm out. I'm not eligible. Now, similarly, the same selection process, now same authorities. Regarding the DLED issue, Supreme Court has pronounced a new judgment on 28. There, the Supreme Court clearly held that those candidates who is having 18 months DLED obtained through NOS, Open District University, they are not eligible for appointment as a teacher. Now, in view of that Supreme Court judgment, my Lord, here in my constituency, many applicants, including me, they have rejected my name, that you don't have a DLED, and many others are also rejected. But though there are many candidates, my Lord, who are remain in the select list, who are only having 18 months in OIS.
Have you pleaded them as parties here?
If some of them.
All of them?
6 of them I pleaded. Those
how
who
do you know? How
are
are
sure.
you privy to the application forms?
The young parents, they know each other in the same area, my Lord. And many more, according to them, many more. But since the writ petition was urgently filed, they were unable to ascertain.
No. So your case is that I am not qualified.
And others also.
So I'll not allow others also,
Equally be treated, my Lord. May I just show the impugned order? I'll just show, my Lord.
Yes.
Lordship, can you see the page number, my Lord? 147, 46.
Of your writ petition?
Of my writ petition.
Okay.
These are the shortlisted one. They have issued,
146.
my Lord. And here they have shortlisted 326 candidates. And there many, according to the petitioner's knowledge, most of them are only 18 months DLED. Now, my name is, my Lord, page number.
Where the judgment of the Supreme Court?
Judgment. May I come to that?
We say affirm for a judgment, yes.
My Lord, Lordship, kindly come to the judgment operative portion. Supreme Court judgment is, my Lord, page number 108, 108. This was pronounced on 28th November, my Lord.
Where's the operative part?
My Lord, may it come to operative portion, page number 138. It's quite a lengthy judgment. My Lord, may I start from para 35? My Lord, as already discussed here and above, NCTE recognition order such and such was issued so as to give effect to the directive of MHRT such and such, so as to provide a one-time window to the teachers who were already working and who, in terms of the 2017 amendment, were required to acquire the minimum qualification prior to 2019. The said order in any case cannot be held to be a direction to the state of Uttarakhand to act in contravention of its 2012 service rules and the advertisement issued on the basis of such. We further find that
who have a 2-year regular diploma are eligible.
They were not
Those
eligible.
people 18 months who did it through distant learning are not eligible.
Yes.
What is the difference? Why?
Now
It's the same degree.
My Lord,
Who they have a BA from distant learning and a BA from attending college? What's the difference?
Yes, my Lord. Here the Supreme Court held the NCT has given only one-time opportunity to those teachers who are already appointed before the arrival of the new RTE Act, and therefore they were asked to obtain this DLED. So they were given special treatment to obtain.
That's why they obtained to 18 months.
18 months. But for a fresh candidates, my Lord, fresh candidates, they need to obtain 2 years. 2 years. Therefore, Supreme Court held that those candidates who has only 18 months qualification and directly appointed for appointment.
So the High Court, whatever High Court decided that they should be allowed to
Yes,
contest.
Patna High Court in Tripura High Court say that it should be equally treated. Matter issue Supreme Court say no, they cannot be equally treated. It is a one-time opportunity for those in service, and fresh candidates, you have to obtain the 2 years full-time diploma, DLED. You cannot hold the distance 18 months.
Yes.
Well,
So now what's your case now?
Now my case is, my Lord.
You don't have a distance DLED.
But
you don't have a diploma and DLET.
But as of
you only
now,
have a B.Ed.
I have a B.Ed.
You're not eligible yourself, and you file this one to block the ones
But
who are not eligible. Now, where's your qualification? Suppose your prayers answered there. How what relief are you entitled to?
I'm seeking for equal treatment only. Equal treatment that those who are not qualified. My Lordship, can you see the last impugned order, page 154. My names are there. Lordship, can you see?
Mr. Charissa, I'm afraid that you can't espouse someone else's cause to reduce the scope of selection. No?
Lordship, can you see serial number 20 is a writ petition number 1. Page
No DLED. Yeah, finish.
My Lord.
So, no
DLED.
Yes.
And number 12 also, 14 also, my Lord. And serial number 38
Okay, then
and
reject
51.
this. So how can you sustain this writ petition?
My prayer is, my Lord, since I'm not eligible because of my B.Ed is no longer valid. And in view of the Supreme Court order. Similarly, in view of the Supreme Court order, 18 months candidates are not valid. Then, my Lord.
So you want him to weed them out now?
It should be, my Lord, equally treated.
Now they're weeding out now. That means they're weeding out. Then you're giving a good chance to the remaining
My Lord,
candidates.
but everyone would have an opportunity, including me, to obtain the.
When you obtain in 2 years' time?
But it is 2 years' time only. My Lord, the scope
So
of.
you want a selection to be stopped till the time you get
My
your
Lord, I'm not
diploma.
My Lord, I'm not doing praying for that. My only prayer is those who have a 2 years qualification, they can go ahead with the interview day after tomorrow.
Very
those who are
simple.
not, those who are not, my Lord, those who have only 18 months,
Yes.
they should not be allowed to participate in the selection process.
Your Lordship,
Interview will be conducted day after tomorrow, my Lord.
Your Lordship, the writ itself is
notice
not
may be
maintainable,
issued.
my Lord. Why it is not maintainable, my Lord? Your Lordship has rightly pointed out that he is not the person aggrieved. Suppose writ is allowed also, my Lord. He will not get the appointment. He will not get the... So the requirement...
his case is what sauce for the goose should be sauce for the gander
Yes.
also.
No, that I will also.
Equality.
My lord,
Equality.
kindly
You
see.
cook no goose. No, you're the goose has been cooked. The gander should be cooked in the same sauce.
Authority, we have the privilege to obtain the
Your lordship,
obtain the DLA within 2 years and scope for applying.
Whenever
now, if
the-
this not
Is it a prayer?
My lord.
I understood the case, yes.
Lordship is well.
Now, what
Page
is
number
wrong with the
by-
petition? I will show, my lord.
Para, my lord.
What is
Para
suppression
14.
and concealment also?
Para 14.
Very unfortunate, but I have to point out.
Para 14, may just start 15, page 15. The impugned notice dated such with regard to private respondents and other similarly situated shortlisted candidates who has only 18 months diploma from NIOS against the law laid down by the...
Can understand another candidate who has DL diploma comes forward. But then like you are nowhere in the picture.
We are seeking
And-
for equal treatment.
Equal
treatment.
Your lordship, kindly see what my friend is saying. Kindly see the averment paragraph 13, my lord. I will just show the first. They have impleaded somebody who are all stranger, my lord. That is the very funny part of the whole petition, my lord. Kindly see the description of the party which they have given. I will show one. Paragraph 2 first, my lord. At page 7. Respondent number 1 to 5 are State of Meghalaya, and respondent number 6 is National Council for Teachers Education, and respondent number 7 to 14 are private respondents, my lord. So they are private respondents, whether they are having DELAD or 18 months, nothing. But your lordship will see paragraph 13 where some averment is there. I quote paragraph 13.
Yes.
That as per law laid down by the apex court, the private respondent and other similarly situated candidate having only 18 months of diploma are also equally ineligible. Like the writ petitioner to face, however, they are allowed to do, allowing the private get the appointment despite. Now, your lordship, kindly see the memo parties. I will point out one name. That is the name of, your lordship will see the person is Sanjeev Goswami at page 6.
Yes.
And he is, my lord, if your lordship will see, he is rejected candidate. 155. 154. Serial number 3 at page 155. 6, sorry. Sanjeev Goswami is a rejected candidate. List of rejected candidate at 155, my lord. Sanjeev Goswami, no admit card, MTAT. He is a list part of a rejected candidate, my lord.
Serial number?
6, my lord, at page 155.
Yes.
And he is not even called for interview, my lord, and the declaration is being made that he is having 18 months diploma. Similarly, I can so many errors, my lord, I have shown. So that is one part of the matter, my lord. Second part of the matter is that whether this writ is maintainable in law, my lord. My humble submission is, my lord, that I have got the relevant judgments and case laws pointing out that writ is not maintainable. Because he is not the person aggrieved by the action taken by the state government. That the case laws are there, my lord. And your lordship will see the first judgment of 2020, my lord. Paragraph 23, my lord.
No need to look at judgment.
Yes, your lordship, law is well settled. Yes. And, my lord, on merit also, what my friend is saying, 18 months diploma, etc., my lord, on merit.
You can't pass orders against people who are even...
And the consideration and everything is over, my lord.
No matter how good your case is.
All judgments, my lord, constitution being judgment, they are not they cannot...
File small affidavit challenge maintainability. Let them fight another day.
Let them file a affidavit, my lord.
I will do
equal treatment, my lord. Same Supreme Court.
Your lordship may not issue notice, only I will file a affidavit. I will place that relevant paragraph in my note.
The writ petitioner in the present proceedings on a prima facie perusal of the pleadings is seeking to espouse a cause for which, if any orders are forthcoming or relief granted, will not affect him in any manner. inasmuch as to the proposed selection of assistant teacher, by sole admission, the petitioner is not qualified. Stop. Next, be that as it may, as objections to maintainability writ petition have been raised by the Advocate General, let a short objection be filed in the matter of consideration after vacation. Just call you so and so.
I filed a miscase also. Only my Lordship make observation. Dispose of my miscase.
Lordship,
saying that my Lord, those who have 18 months, 18 months
No.
candidate may be subject to outcome of the writ petition.
Your Lordship, when writ is
No,
not
I will
maintainable,
bring-
they
I'll
are
bring the
trying to
judgment.
put cloud
I'll
on
bring
the
the law also. Try to bring the law.
Interim prayer of any shall be considered together on the next date.
Lordship may have it on 19 so that because we are in the process and the matter will, because we have appointed all of them or a large number of them. Now there will be some.
Let's on 20th.
20th, Your Lordship. May have it on 20th.
Mr. President.
Oh, hopefully, they will file, learned HO will
Well,
file
I'll
the
file it
affidavit.
by Friday. By Friday we will give you.
Not be in a position to give my rejoinder.
Friday we will give you by Friday, but in 2 days. We have to only.
By 20th, yes. On 20th, not authorization. Yes, Dr. Mosika, last leg posting. Any instructions?
My Lord, this on last occasion, my Lord, this matter was heard, my Lord, and Lordship was not inclined to, though this is not reflected in the order sheet, my Lord. My Lord, I placed my instructions on the last day, my Lord, that he requested for posting in 4 places, my Lord. That is, Your Lordship will find that page. Page 14.
My Lord, page number 14, my Lord, annexure 1.
You file affidavit then?
My Lord, I'll file an affidavit.
Yes, we'll let him file affidavit. Dr. Mosika, please.
My Lord.
Yes,
Till then, my Lord,
no entry, my Lord, in this case. He's a high ranking officer, my Lord.
After it's not been, affidavit as directed by order dated 17/11/2023 has not been filed. Learned DSC please phone allowed for the 1-2 weeks time to file the same, just thereafter. But
obliged.
My Lord.
Hearing 37.
Here.
37.
yes, MSB Kharwan Lang. After vacation?
Lordship.
Not just in getting your money.
No.
No.
Your Lordship, Senior Counsel, because this matter has not been heard.
Is an escrow account, that one?
Escrow account, Your Lordship.
Regarding deduction of your service.
Service tax.
If on the prayer of council parties, this is matter after vacations.
Highly obliged.
39.
Please, Lordships.
Yes, MS Lingua.
Lordships, pursuant to the last order, my Lord, the petitioner's family members had come and given us certain, my Lord, the mobile and certain other things which are required to be given to the IO. But here, my Lord, unfortunately, the IO has
Passed away,
since
Your
expired, and they are yet to re-endorse
Last
it
month,
to
Your
us.
Lordship.
I'm
So
praying
it has
for a
to be
little.
re-endorsed, Your Lordship. It has to
they
be
can expedite it,
re-endorsed.
my Lord. So it's regarding the death at Nepal.
Okay, okay. Mr. S. Debs submits that the IO entrusted with the inquiry or with the case has
Passed away.
expired last month, and the case is yet to be
Re-endorsed, Your Lordship.
re-endorsed. What happened? You got the mobiles back?
No, my Lord, if Lordship sees the last order, a prayer was made, my Lord, that whatever the IO needs he can contact, whatever the IO needs for the progress of the investigation, he can contact it through the advocates.
After vacations.
So once
hopefully by next year the new IO would be in place. Yes.
Obliged.
Obliged,
One.
Lordship.
Yes.
May I please,
How long will take?
10-15 minutes, Your Lordship.
How to ask on the hearing? We can complete this today.
I'll only facts are not in dispute, my lord. Only
What
the-
about the government?
Your Lordship, so far the state is concerned, Your Lordship, I'll take hardly 3 minutes.
Your district council?
I'm district council.
Oh, sorry.
For the private respondents, I will also not take much time.
Yes.
Okay. May I please, Your Lordship. Your Lordship, on the last day or...
Why don't you do one thing?
Yes,
You give your bullet point submissions, we'll reserve it for judgment.
Okay, Lordship. I'll give my written arguments along with the judgments, Your Lordship.
You do that also.
Detailed written argument. Just
Yes, bullet points.
Whatever you give, detail, whatever, yes.
Yes, Your Lordship.
Yes, because the very simple, the only thing is that you're saying
Yes,
the
Your
post not advertised
Yes, Your Lordship.
and appointments made against post not advertised.
Yes, Your Lordship. There was no... My main arguments, Your Lordship, is there was no fresh advertisement.
There's no fresh advertisement.
And they were given appointment clearly on the basis of waiting list. And also, Your Lordship, they don't have any recruitment rules, KHDC. If the KHDC would have made changes in their recruitment rules, then it would have been some impact. Yes, Your Lordship. There is no recruitment till date, and this Honorable High Court, in a division bench matter, clearly directed Respondent 1 to frame recruitment rules within a period of 3 months. However, that is not done so. That is
You bring that on record
Yes,
also?
Your Lordship. I have annexed in my judgment, Your Lordship. So, but then...
that's not a pleaded case, my lord.
No,
doesn't matter. We'll take
Trying to add
consideration.
something
If that is some consideration, we will examine that also. Why not? If it's relevant, why shouldn't we consider it?
It's neither pleaded, my lord, nor we got a chance to respond to that.
Your Lordship, since there is my assumption that
Okay, you give that thing. Let them you file your argument by 19th.
Yes, sir.
Or 20th on closing day.
I'll supply them the copies also,
Yes,
Your Lordship.
yes. I'll just write parties substantially heard. The period without filing arguments. That is will not be filed by 20th. By 20th December. Then you make me work notifications.
Yes.
Yes.
Oblige, Your Lordship.
And one thing, you kindly supply the
judgments.
Yeah, the copy of judgment. So I won't have no need of citation.
Yes.
Just make photocopies.
Yeah, I've made a
Lordship
photocopy
will
here.
enclose in the bullet point.
Yes, you kindly
Yes.
make.
Lordship, yes.
You
We'll
do
do
kindly
that.
annex. If not too long, the judgment also.
We'll
Otherwise, I won't
We'll
have
do
to-
that, Your Lordship.
Yes, Your Lordship.
Oblige.
Oblige, Lordship.
Yes, Rajha.
My lord. This is, my lord, that disability pension, my lord.
Yes, the judgment of Justice Thakur.
My lord.
Thakur, no.
No, my lord. That's Uttarakhand.
Yes, from Himachal.
Lokpal Singh.
Himachal, right?
Right, my lord.
Uttarakhand.
Uttarakhand, sorry, Lokpal Singh, sorry.
That is in appeal, my lord. They preferred an appeal. Assam Rifle.
Therefore, appeal against that order. What
Against
happened appeal?
that appeal, my lord. It's a division bench order, my lord.
Of this Lokpal Singh.
Yes, my lord.
No, this is single bench order.
DB is also there. Division bench is also
DB order. Next year.
DB.
One thing, Dr. Mojika, also in that, see that this matter, just where the other council opinion for the matters passed.
Which
You
Pandey
see
opinion?
Yes, yes. But the thing is that district council is on the recruitment process is a different footing also. It's by executive committee themselves, without having any rules also. That's the thing also, because if there's a directive that rules be made, so on and so forth, that's the thing you can say. Anyway, but you meet that point in the argument. Just
This matter will be taken next year.
next year. He retired. He was retired when?
My lord.
Taken off from service which year?
1977, my lord.
77, he left
78,
service.
my lord. He was, my lord, interesting, my lord, that he was retired, means voluntary
not voluntary, my lord. He was forcibly retired, my lord, on the ground that invalid pension, my lord. In that discharge itself, my lord, whether he is fit for other police job.
They said yes.
Yes, my lord. If it is fit, then why he has to be retired, my lord? Why?
No, police and Assam Rifles are different.
My lord, it's a police, Assam Rifle, re-employment, yes.
In other, anyway,
yes.
we'll hear it.
My lord.
But 77.
My lord.
78, he was
45 years, my lord. He's coming after 45 years.
My lord, he is approximately 70 years, my lord.
And so you woke up one fine day.
My lord, it's a...
You've heard of Rip Van Winkle?
My lord?
You've heard of the story of Rip Van Winkle? Rip Van Winkle, you know who was Rip Van Winkle? He was a person, it's a folk tale from Europe, you know?
My lord,
so one day he went to the hills and he saw these people playing, you know, they're called nine pins like those bowling. Then he had some wine they gave and he fell asleep. And he woke up after 20 years.
My lord, that's...
So we can apply the same analogy of Rip Van Winkle to that petitioner.
That cannot be, my lord.
Yeah. You look up, you Google Rip Van Winkle, then maybe you'll get some points on your case. What's left here? Why is it adjourned last time?
State was to come with judgments, Lord.
Yes. It's regarding
this
that
matter was
fifth pay commission.
Yes, my lord. This matter is not completely heard, my lord.
Not completely heard.
The hearing started, my lord, but thereafter, on a point of, because...
What point?
My lord, here, my lord, the question was whether the reference was made to the rules, my lord. Now, if we go by
reference
the rules...
made to?
The rules, 2018 rules, my lord. And the instruction which is issued earlier, my lord. My lord will kindly see. Now, my lord, case of the petitioner is that, my lord, they, according to them, they are the work charge employees. Now, my lord, once the notification says that work charge employees...
No. Their case, if I remember correctly, is that they were given that accommodation, that they be given the benefits of the fifth pay commission to work charge employees. Now, what you're saying is that by a notification or memorandum issued 2017 or 1997.
No, my lord. That is notification came earlier, my lord.
That benefit's been taken away from them.
1997, my lord, that is earlier. That is issued by the government of Meghalaya, my lord. It is much earlier date. It is 97, my lord. Now, as far as, my lord, what the 2018 rule says, my lord, this is a very clear terminology in the rules, my lord. If I may...
Where are the rules?
My lord, right now I am referring to WPC number 403 of 2021, my lord.
Okay.
In the affidavit, my lord, we have brought out the rules, which is starting from page 35, my lord.
Your affidavit.
These affidavits filed by the state.
Page 35.
Page 35, my lord. Annexure 4.
Yes.
Now, my lord, I may be allowed to refer to Rule 2 and Sub-Rule 2, my lord.
Yes.
These rules shall not apply to.
What about 2.1?
2.1 save as otherwise provided or under these rules shall apply to persons appointed to civil services and posts in connection with affairs of the state of Meghalaya, including persons in work charge establishment holding posts carrying identical scales of pay as admissible to corresponding categories of employees in regular establishments.
Yes.
My lord, in my respectful submission, my lord, this work charge would only include those who are appointed prior to 97, my lord. The petitioners would not be entitled, will not come under.
Affidavit?
Yes, my lord.
Okay.
We have stated. They will not come under this category, my lord. Even assuming, my lord, there is a confusion, my lord. Now the rule clearly says who can clarify that, my lord? That is, my lord, if I may draw my lord's attention to, my lord, page 46. This is 15, my lord.
46.
46, rule 15, my lord.
Yes.
Interpretation, my lord. If
But
any
they already
question,
filed representation, correct?
my lord,
They already filed representation.
they already
correct?
filed representation, and
your one's very cryptic kind of reply.
and the department has, my lord, rejected the representation on the ground that their employment is, they cannot be.
So the interpretation of the response of the government is that they're not eligible because of that memorandum of 1997.
My lord.
That it shall not be any further work charge appointment.
My lord.
Correct.
My lord.
Now, if I correctly remember, last time they said that some people who appointed after that who have been given the benefit of fifth pay commission. How
My
do we
lord,
address
that is not correct, my lord. But well, if my friends can bring anything on record, my lord.
That is exactly my case, my lord. There's a stay also. I was being paid, my lord, and this year, before filing of the writ petition, my lord, my pay was reduced to half.
And my lord, this rule 2, what it says, my lord, if I am allowed to read further. My lord, rule 2, sub rule 2. If I am allowed to read, my lord. If I am allowed to read, my lord, rule 2, sub rule 2. These rules shall not apply to persons not in whole-time employment. Now, admittedly, my lord, the writ petitioners, they have been appointed from.
Does not apply to this person. If you want to qualify to 1, to 2, what's to 1 does apply to those people work charge is appointed after 97? Why don't they clarify it here?
My lord, if required, we will get another clarification, my lord. That is not an issue, my lord. Because the representation itself, my lord, the decision of the government itself is clearly clarified, my lord, which is also included in the, if not this affidavit, my lord. Yes, my lord, in this affidavit itself. That is 23rd March 2020.
Which page you reading?
My lord, this is my friend's writ petition, page 47, my lord, annexure 5.
Page?
Page 47, my lord. With reference, if I may read, my lord.
1 second. Yes.
This is the letter impugned in our writ petition, Lord.
With reference to your letter on the subject cited, I am directed to say that the Government of Finance PR Revision Department have stated that as per rules of its memorandum on implementation of the 5th Meghalaya Pay Commission, the revised pay is applicable to work charge personnel. So this is where it is clarified, madam. Is applicable to work charge personnel who were appointed prior to 27/10/1997. Further, since appointment of work charge personnel have been banned.
Who's the competent authority you said to decide under 15?
Finance. It's the finance.
It's the finance pay revision, madam.
And this notification is issued by the Under Secretary to the Government of Meghalaya.
Where's the communication of the finance? Produce it.
Madam.
Where's it? How have they stated that?
My lord,
this one, they refer to a letter. The letter must have reasons. Where's the reasons?
Yes, my lord. One.
You have it with you? The letter of the finance department?
It should be there.
Have you annexed the affidavit?
In my affidavit, if I am not mistaken, my lord.
The finance letter, where is it?
It's just allowed to verify, my lord.
Is there? At the finance department? Since the competent authority decide. They don't have it with them.
My lord.
Where is it?
My lord, I am. This one I am referring to, my lord, another writ petition which is 513 of 22, my lord. Precious Stone Pale and 18 others, my lord.
Which one?
That is, my lord, that serial number. My lord, that is at serial number 52, my lord. 52 of the hearing list.
Is there letter, Francis?
Yes,
Letter there?
yes.
Very good. Page?
My lord, this will be page 9, my lord.
Of the writ petition?
No, my lord, page 9 of the affidavit in opposition which is filed in that case, my lord. Typed copy, my lord, is at page 9.
Does not impugn his letter?
No, my lord.
Provident Fund.
This page 97 letter, I'm talking about a clarification of rules. You said that that Rule 15 provides that for clarification of the applicability of the rules, they have the Finance Department as empowered under Rule 15. Now you showed a letter that PUD is referred to some finance letter that says that, you know, like that.
My lord, my apologies, my lord, that will be annexure 2, my lord.
Page?
Page 11, my lord.
This addressed to this public, to this present secretary.
Yes.
Where is the letter of that referred to by the PUD?
My lord, of course, that is not on record, my lord. So
Then?
we'll have to bring that on record. But here it is, here also it is clarified, my lord, by the finance. They had written to the finance has clarified, my lord.
Page 11.
Page 11.
Page 11.
Yes.
This speaks in my favor.
CM did take the same excuse as for those appointed after cut-off date.
The question of revised pay, annual increments, etc. does not arise, as they were appointed after the date. The government, white letter number letter, strictly banned appointments under work charges.
My lord, in my humble submission, my lord, the question of interpretation will come only when there is ambiguity. Where is the ambiguity in the rules, my lord? It makes it very clear.
No.
My lord.
But court looking at the source of the ambiguity is being created by the state respondents. All you understand? There has to be clear that there has been a rejection. You know that if we can take the rejection, then we'll decide the matter.
And as far as that letter which is being referred by the...
one second, let me submit. 1997 letter, my lord, it is only a guideline to all state departments. Do not appoint any more...
my lord, that has come before hand and government has taken that into consideration. It is not that this letter has come subsequently, my lord.
Then he continued putting them under the 5th pay. Why?
Correct. And for that matter, why were we paid the 4th pay?
No, that's a matter, that is a matter of policy decision, my lord. If the government decides to give them some benefit, they have given, my lord. Subsequently, if the government...
How will a policy decision
lord,
come in the way of statutory rules, my lord? They have to amend these rules. The rules cannot be in conflict
with what the rules
policy decision cannot be in conflict with rules. Well, these
are
are rules.
Not what the rules
These are rules made in exercise of powers under Article 309 of the Constitution.
My lord, what the rule says? Categories, persons who will not be entitled. They have conveniently put themselves in the category which suits them, my lord.
Well, Rule 2 says categories
say
of
they
government
work charge employees who were appointed after the rules 2018, correct?
My lord.
Does say anywhere about post 97 appointees.
That is our rule case, my lord. If
My lord,
at all the government wanted to make any classification, the classification would have been made in the rules.
My lord, if there is any ambiguity or any confusion, my lord, this is the department which can issue the clarification, my lord, as per Rule 15.
Don't issue a post after the hearing, but let's see the file.
My lord, if I am just allowed to read
where is this PUD letters you referred to? It's in the affidavit. Or they refer to the finance letter.
Yes, my lord, in the earlier affidavit, that is, again I take my lord back to the original case. That is, my lord, this letter is at page 48, my lord.
Of the first affidavit?
Of the first affidavit, my lord. 23rd March 2020.
Where is this letter? Yes. Where is this letter?
Typed copy, my lord. It is in WPC number 403 of 20.
That's not the one. This 43 years, 48 years. Where is that the interpretation?
My lord, interpretation is, my lord, at page 46.
Oh, this is from the PWD only. You just typed out. It is a type copy.
My lord, issues of approval. This letter will have to
46
get it, my lord.
Is the rule.
47, my lord. Here it is written, my lord. The issue 47 is the letter, my lord.
48 is the same.
Yes, 48 is the typed copy. 48 is a typed copy, my lord. These issues with the approval of
Promise this court, from the after won't be that is be traveling. Otherwise, we would have continued the hearing. You just bring the records. Stop. Attention of this court has been drawn by the learned government advocate to a communication dated 23rd March 2020, which is annexed as Annexure 5.
This is
in WPC number.
This is Annexure 9 in my writ petition. WPC number 403.
No, speech 40.
But I am referring to my affidavit, my lord.
Affidavit,
yes,
which is from
page 47, my lord.
5 to the affidavit filed by the state respondent. Stop. Approval of the same reflects that the letter was communicated. Our legislation shows that the decision to deprive the petitioners was in view of a decision taken by the government in the finance department. Stop. Next one, Mr. Kibu Parachaji, Learned Counsel for the State, has also submitted that the same has been decided by the finance department in view of Rule 15 of the
2018 rules.
What rules are it called?
My lord, pay revision
of the revision of pay rules 2018. Stop. Accordingly, in view of the ambiguity of the decision arrived at by the state respondents, they are directed to produce the relevant
letter, my lord.
Letters by which the finance department had arrived at this decision. Stop. These applications. We'll clear it up. Let's just see the letter, then. So there'll be no ambiguity.
62. Clearly, we don't see any ambiguity.
Yes. How much amount payable?
My lord, the last order was there. The last opportunity is granted to the
Exact amount
respondent.
payable to the on the goods.
My lord, in fact, for release, my lord, for provisional release, they themselves valued it much less, my lord.
Okay, you accept that, Mr. Rasgupta?
No, my lord, that was a provisional release application.
Yes.
And that was in consideration to the additional cost as per circular.
What is the amount you arrived at?
That is 3 times to actual value. That is penalty, duty, and interest. Penalty, duty, and redemption fine was taken into consideration. 100%, all this. So it comes to 288 per kg, more, as per provisional release application.
So what amount? What's the amount they arrived at? You give that amount, the don't file objection, then we settle it.
My lord, we are saying that the department did not derive any benefit, my lord, of this.
No. What is the amount you arrived at?
My lord, let me just please. They themselves valued at 48 lakh rupees, my lord.
So let's see, you pay 48 lakhs with interest.
My lord, we are not saying that, my lord, but we are only, if it comes to that, if we have to pay, my lord.
The order of the court. When was it seized? 2017. When was it seized, Mr. Gupta?
2017, 29/10/2017.
So you pay interest, Dr. Mazika, from 2010-2017 till date?
6 years already elapsed, my lord.
Take 48 lakhs.
No, my lord, that as per is settled law, my lord, it is a settled issue by the various High Court and Supreme Court.
Yes.
Seizure value.
But this is
plus
by
interest.
own
Plus
admission.
interest.
See,
It is-
see your
it is
letter
not-
only.
it is not
The
an admission,
claimant
my-
applicants actual rightful owner locally produced against so and so when 30,000 kilos exorbitantly valued at rupees 88 lakhs, 275 per kilo. Caesar memo so that is also. Actual market value is actually 48 lakhs as mentioned tag invoices 7 and 8 both dated so and so account with consignments. That the claimant received trading so and so the value and this is actually valued. This is by own admission.
No. There is for provision, it is, my lord. That was as per circular, my lord. We have to pay penalty, duty, and redemption
So
fine.
what do you say was letter this
So-
2018 then?
Well, what happened, my lord, after the betel nut was seized, my lord, because these are perishable in nature, my lord, so there is a provision that provisionally this can be released on payment of a security bond, my lord. So that time they themselves said that the total value is 48 lakh rupees only of my seized articles.
That is one.
No, my lord, it is my objection, my lord, because
We'll record that. They have to indicate the amount you file your objection and we'll pass orders.
okay, I'll file objection.
Dr. N. Mozika, then a DSG with so and so submits that by the own admission of the petitioner by letter dated 4/1/2018 addressed to the Commissioner Customs. The value of the betel nuts was estimated at rupees 48 lakhs. Stop. He therefore submits that if any amount is due and payable, the same shall be the amount from which is a limited amount by the petitioner. Stop. Mr. Antasupta has vehemently objected to the same.
Yes, ma'am.
And praised the admit out to file objection indicating the exact amount payable to the petitioner. This is a matter after 2 weeks.
After 2 weeks.
Yes. Copy of the letter dated 4/1/2018 taken on board as part of the record. Yes. You file objection, we arrive at some amount.
Much obliged.
Yes. But you're not less than 48 lakhs, remember that. It won't go below that. After his objection, maybe some other figure will be arrived at. Yes.
May I please, your lordship? Lordship, in this, I just want to file a small additional affidavit.
Why?
For the
Hearing
respondents, yes, lordship, respondent 4, 5, and 6 were not complying with the CCS rules, lordship. Because my client, there is a change of circumstances. In the earlier writ petition, my prayer was only for the issuance of the duplicate certificate. Now, lordship, the pensionary benefits are withheld, just for the verification of the caste certificate.
MSSK Nagaram submits that due to subsequent developments.
Lordship, if it could be on the 20th, I'll file it.
We have to file a small affidavit. She praised that matter will be listed on 20th. There are instructions, yes, of course, on 20th. But for the said affidavit, yes.
Highly obliged, lordship.